We got three here. All right, it is 9:02 a.m. on Tuesday, August 27th, 2024. And I call to order this meeting of the Maine Gambling Control Board. My name is Steve Silver. I am the board chair. Before we go any further, I'll just explain the circumstances under which we're holding this meeting and set up some ground rules. This is a hybrid meeting. The physical location is at 45 Commerce Drive, Augusta, Maine, or the Fallen Heroes Room. There is a virtual attendance option for the public and for board members, consistent with the board member remote participation policy adopted in July 2021. It doesn't appear we have any board members on Zoom right now, but they should be joining. So the board expects that members of the public who attend the board meeting virtually will be able to provide public comments to the same extent as everybody in the room. And I think everyone's muted, should be muted on Zoom, but please do that until it's your time to talk. And then if you can, when it's your time to talk, turn your video on, that helps out. Gambling Control Unit, on behalf of the board, posted notices of this meeting on its website with instructions on how members of the public could access it. In addition, the unit, on behalf of the board, sends agendas in advance of the meeting to those who requested so by registering the request with the unit. It's the board's sincere hope that all those interested in the subject matter at today's meeting have received notice of the meeting and how to participate electronically. So this time I'll introduce the other board members. Confirm that we have a quorum. When I call your name, identify yourself for the public and where you're from. So we'll start with you, Ms. Green.
Good morning, Sarah Green, South Portland.
I don't know this guy to my left. Chief March, welcome back.
I hear that a lot. Noel March, and I live in Hamden, Maine.
We're glad to have you back. Is Ms. Bickmore on?
No.
Okay, Mr. Hanslet? All right, and I'm Steve Silver, and I'm also from South Portland, which was a beer drive this morning. A lot of people just drove through fog the whole time. So we've got three people, so we continue. If the others join us, just let us know. And obviously, we've got a number of guests you can see from the agenda, but Executive Director Champion's here and Commissioner Sashta, who we'll be hearing from a bit later. So with that, dive right in. The first thing is approval of minutes from the July 16th meeting, which Chief March, you weren't here. So Sarah,
Yeah, I'm just curious. I don't make comments. I'm curious. There's still marked as draft.
I think that's just for our.
Yeah, I moved to accept the minutes.
Yeah, okay, well, seconded or not, so you can both vote, just in favor of approving.
Aye.
Okay, as well, so we'll get that done, and with that, the operations report, this meeting is coming from Executive Director Champion.
Good morning, everybody. In regards to operations in July 2024, there were 3 shipments of machines and our associated equipment shipped to and from licensed facilities. There were 51 work orders completed, which ranged from replacing revoked software to changing teams, options, and communications issues. There were 68 entries in the inspector pass-on log to share information not only from within the facility, but also between the facilities. This has been an effective tool for the inspectors. There are currently 6 formal complaints with status updates and are reported in the complaint dashboard. 1 is pending referral to the board in the consent agreement. 1 is under review by the complaint committee. 2 were dismissed by the director. 1 is under review by the investigative committee. And 1 has been responded to by the facility and will be forwarded to the investigative committee. There were 6 additional minor activities that the unit will continue to monitor for the development of trends and having the ability to bring those to the attention of the facilities to resolve before any formal action is taken. 2 trends were brought to the attention of one of the facilities involving gaming badges not being worn and dealer procedures, which were not similar in nature. There were no patron complaints, and there were 15 self-exclusions in the month of July, 7 1-year, 2 3-year, 1 5-year, and 5 lifetime. Total as of July 31st, we have 111 1-year, 48 3-year, 54 5-year, and 248 lifetime. I do not have the reports from the local PD at this time, but will supply that information in the future. Monthly meetings with the inspectors have been very productive. The inspectors have adapted to the change to facility-based monitoring, and we are committed to providing the board with results and not necessarily the process. We now have 2 workstations at each facility, equipment updates that have been made so that the inspectors work smart, not hard. And I thank each facility for their upgrades to the offices as well. That's our report.
Director Champion, the totals for the self-inspection, is that all time or just for the year? You say 248 lifetime, like.
Yeah, that's total as of July 31st. There's 240 on the registered lifetime. And in my director's report, I'll give you an update as to the transition in regards to the new law, moving the legacy list over to state list. Okay.
Any questions for Director Champion?
Just, who's on the investigative committee?
The investigative committee is Vicki Gardner, myself, and 2 AGs. And then the complaint committee is the commissioner, assistant commissioner, myself, and the AGs.
Okay. Anything else? Oh, there's Joe.
Kelly's on too.
Are we able to get everybody on the screen? I used to be able to see all the squares.
Oh, if she turns her camera on.
There we
There
go.
you go.
There's. Welcome. All right, full house. Okay, let's move to the financial report from Amanda Spencer.
Good morning. For the financial report for the month of July 2024, total tax revenue paid from both casinos to the state of Maine decreased by 8.31% or $555,448 in July 2024 compared to the same month in 2023. 2024 year-to-date tax revenue collected from the casinos was $39,582,058. This was a decrease of 4.14% or $1.7 million compared to the same time last year. Specifically by casino, the Oxford Casino reported a total net win of 7.5% from slot machines and a total win of 22.84% from table games in July 2024. The Hollywood Casino reported a total net win of 8.35% from slot machines and a total win of 26.83% from table games in July 2020. In the area of advanced deposit wagering, we observed a decrease of 18.3% for July 2024 compared to the same month in 2023. 2024 year-to-date tax revenue collected from in-state and out-of-state races was $128,767. This was a decrease of 9.2% or $13,092 compared to the same time last year.
Any questions from Ms. Spencer? All right, we'll go back to Director Champion for his executive director report.
All right, good morning. Just so everybody knows, I could not retract the publication of facility-based monitoring system rules at the advice of the Secretary of State. He basically said when they retract, most people don't catch that. They still send in comments. So he said it creates a lot of confusion. Knowing that we may have to publish a 4th publication, I let it go. The responses and the recommendations to the 3rd publication were placed in the Dropbox for board review, and comments to that 3rd publication were entered in red. Legal review of rules regarding Chapter 28 advanced deposit wagering is continuing with a deadline of September 30th. Applications are ready for publication upon rule adoption, which at this point would be after the October 15th board meeting and subsequent Secretary of State adoption. Rulemaking drafts for Chapter 13 and certification of a lab to include an application will be ready for the October meeting. The GLI report on the transition will also be presented in October. And the 4 bills that passed in the last session have become law. I would ask if you haven't, and I understand that Cammy has gotten the legacy list, but we will need the backup paperwork for each individual that signed out. So we have that on file should they want to be reinstated. I understand the only ones that will be forward are lifetime. So all the ones, 5 years or less have actually timed out. So the list will only include lifetime. So we'll add those and be able to report those to the board at the next meeting. And that's my report.
Bill, with the new, it was part of the sports betting where we merged all the lists for exclusions. So if the folks, like you said, there were 15 in the month of July at casinos, does that exclude them from sports betting?
No, they were strictly casino. We have the application ready, but now an individual, when they exclude, they can exclude from one or all, but they're able to select which area. And then of course, each month, depending on what area, like they do casino, fantasy, and sports, will notify all fantasy sports operators at the same time to be notified the casinos.
Okay.
Yep.
I actually want to back up and sort of open the floor for the Oxford Hollywood folks. We've seen consecutive drops in revenue, and if there's anything that the board can do, or anything that we've done that's effective, it's just the economy, it's that there's sports betting now. And you don't have to talk, but
Definitely seems like it. Pick it up.
okay. And then in the drop, I noticed there was a reduction in Oxford of the tables offered, that staffing issues, or? All right. Appreciate that. Okay. So, I guess I should ask you, is it okay if I take something up for her? Yes. Yeah, so we've got some we have some guests from the main CDC, and I don't want them to wade through the whole thing that we've got coming up, so I thought we could jump to that. Everyone's okay, so, I think it's Jamie and Megan, but hi,
Good morning.
you could, if you want to come up here, so camera can get you.
Sure. I'm just getting over a cold, so I apologize in advance.
And, I don't know how much you know, in terms of the background, but the reason why this came up is a few months ago when we were talking about the inspectors changing and the folks coming to self-exclude, nobody being at the casino to handle it. Casinos weren't sure what to do, and AdCare can only be so many places at so many times, and that led to questions of, well, where does the money go? Because we know AdCare has a contract, but beyond that, we don't know. So that's what prompted this reach out. So I don't know if you have anything to share, and I'm sure we have some questions.
Well, first, let me introduce myself formally. I'm Jamie Burke. I am the Associate Director of the Division of Disease Prevention at the Maine CDC. And my colleague Megan Scott is here with me today. Megan is our program manager for our substance use prevention programming, which includes the gambling work in her portfolio. So I'm going to try not to get too into the governmental weeds, but provide you some detail about where we're at and the different processes that we're going through, and the things that we've undertaken in the last year or so since our revenue has increased for our gambling work. So Prior to this last year, we received around $98,000 for our gambling addiction prevention and treatment work. The majority of those funds we provided to AdCare. None of the funds are kept in-house for our staff. We pay our staff with other revenue sources. And so we gave those funds to AdCare, and they really help oversee and coordinate the work. As many of you know, in the last year, legislation was passed that directed, read off my paper so I get the verbiage right. 1% revenue equal to 1% of the adjusted gross sports wagering receipts are also supposed to go to that fund, which we were excited for. This is our first increase in this fund so I think since its inception. The caveat I will note is that we weren't sure what 1% would be. So what we've done is, in the meantime, we've ramped up our work. We've directed other funding that we had that was unrestricted toward our gambling prevention services. We've increased Lori at AdCare her time to full time. And Lori's really been working closely with us to increase the services that we provide across the state and also research what could we be doing? What are the needs of our constituency with these new funds? We've also directed additional revenue to 211 so that they can increase their ability to handle incoming calls. Their previous budget was $2,500 a year, and we've increased that to over $22,000 a year. So now they have added an additional 0.5 FTE to handle those incoming calls. And so what we've been working on is getting a sense of what that incoming revenue will look like, and also ramping up with some other revenue to meet these immediate needs. So as of today, we receive quarterly revenue transfers, and the revenue has fluctuated. The initial revenue transfer occurred in January of 2024, and it was just over $9,000. The second quarterly transfer happened in April, and that increased up to $124,000. And then the most recent revenue transfer was just around $100,000. So there is some fluctuation. And as you can see, it's a pretty dramatic increase from what we had received historically. Some of the mechanisms of state government, just for you to be aware of, any money that is above $5,000, we're going to need to put the services out to competitive procurement. So that takes time, which is part of the reason why we've used additional revenue from other sources to respond to the increased need that we're seeing in our gambling prevention portfolio. We're also really committed to providing evidence-based services in the state. So we've been doing research, seeing what other states are doing for their gambling prevention and treatment programs, looking at the evidence base, and then assessing what the needs are of our constituency. Moving forward, we will have to initiate a financial order to be able to actually spend those funds because there's not an actual dollar amount tied to that legislation. It's a percentage of revenue. And so it's kind of like having a savings account, but you don't have a PIN to access it. We have to work through the governor's office and the Bureau of Budget to have a set plan because we are stewards of taxpayer dollars. And so we have to be responsible for that. And when we move forward with a financial order, we will have to present a solid plan for what that looks like. So we will do that. And then those funds will be available subsequently to us as they come in. But I did just want to provide a little background that even though the revenue comes in, it's not immediately available for us to spend. And that is not my bailiwick. I am not a financial member of the Department of Health and Human Services. So that's about the extent of my knowledge around the financial stuff. But I didn't know if folks had questions.
So I do, but I want to go back to that. Who can we go to as a board to get the ability to spend that money? Because the need is now, right? Sports wagering is live, been live. That seems crazy. If the legislature directed 1% for this fund, you should be able to use that immediately. Is that the governor's office? Does it go through the full legislature?
No, I think, and honestly, I wish that our financial program person were here to explain it in more detail, but part of it is that we need to have a plan of how that revenue will be spent. And so it's hard to make a plan for how you're going to spend money when you don't know how much money you're going to have. And now that we have a better sense of that, we've been working internally. We actually have a list of programs that we're exploring, and then we'll be able to put forward a financial order. Financial orders take approximately 8 to 10 weeks to be able to draw the funds down. So it's not like it's a incredibly long process. But we did have to have a plan to spend before we could put in the financial order.
Do you have the plan? Like, what is the plan?
We have some plans that, some programs that we're exploring. So we're looking at, when I again read this, because I don't want to get this wrong. We're looking at programs, evidence-based programs for financial counseling services for people in treatment and their families. There is a nationwide self-exclusion act, and we're looking to see if that's something that we could be added to. We're also looking at programs that embed education, responsible gambling measures, self-exclusion services, and general gambling resources within casinos themselves. We are looking at whether or not telehealth gambling counseling can be provided within the state of Maine. We're also looking at some other national groups and seeing whether or not it makes sense to become involved in those as members. There's the juice worth this week, so to speak, to pay to be a member of certain groups. We're also looking at a certification option for gambling treatment providers so that there's a standard level of service across the state so that no matter where you access care, you're getting the same level of service. So those are things that we're exploring.
So given that we expect the increase to be due to sports betting, and the sports betting demographic seems to be very different than, or appears to be different than casino. Is there anything being done in that area to look at sort of that specific demographic? It's also such a different way of gambling, right? You're sitting at home on the couch, watching a game, whatever, not driving. So how is the work that you're looking to do different for the sports betting? The person who's having an issue with sports betting versus an casino.
So that's something that we're looking into is how do we market these services in a different way so that folks, like you said, that are sitting on their couch, how do we make sure that they know that this is available to them? So we are looking to direct additional resources to marketing so that people know, oh, this is something I can
I would
access.
suggest it's much more the marketing too, right? It's not just how we reach them. I think it's very different. It's a different age and it's a different mindset too. I just assume there are other states that develop programs specifically for sports betting. I just don't. I mean, I would think you'd want to add that to your list.
I will make it.
Let me back up because at the casino part, my understanding is by statute, there's only $100,000 that's put to that fund. It's been that way for 10 years or so. Last year was 7.3 million that went to the general fund. By statute, they only give you 100,000. If you could wave a magic wand, how much would you want?
That is not something I was prepared to answer today.
I mean, is there a need? Like, are you saying is 100,000 enough? It seems like we could increase AdCare or others. I mean, where I'm getting at is I'd like to put in a bill, who knows where it goes, but to say that statute hasn't been looked at in over a decade. And in fact, when you read it, it was like 50K, right? Up until 2000, whatever, then it became 100. There should either be an annual increase or something tied to what we're seeing on the revenue, but to say, in 2023, 2024, Mainers are going to gamble both in casinos and sports wagering nearly $1 billion. We're going to give 100,000. That's crazy, right? So I think what would be useful, you don't have to answer now, is to think like, is there something we could justify, whether it becomes 200 or 250 or 500, who cares? That we can go to the BLA committee and say, you folks haven't looked at this in a decade. This is how we could spend it, how we could use it. I mean, even if you did no new programs, no new nothing, the cost of running everything has gone up dramatically. So there should be some trigger in there. That's what I'd like to do on the casino side, because by statute, that's all you're getting, 100K. Whether they transfer 7 million, 1 million, 10 million, whatever, that doesn't make sense. I have no idea how receptive folks will be about that, but the BLA committee in looking at fully, iGaming, all the other stuff they're looking at. Every 2 minutes, all we talked about was we're gonna treat addiction, we're gonna do this, that. I think it's a great opportunity to increase those funds. So that would be my one homework assignment. It's like, what's a realistic ask? I'm willing to go do that. I think we've got a little time before we have to submit stuff for the next legislature. But let's do that.
Mr. Chair.
Yeah.
Just help educate me. So the statutory money of some 100,000 is
That's from the
dedicated for casino and the sports wager.
different,
1% can only be dedicated to sports wagering prevention.
different things. So when the legislature passed that first slots, then it became slot tables. That statute says it's 100,000 transferred to the fund, the addiction fund. Period, 100,000. Doesn't matter if they generate 101,000 in tax revenue or 10 million. That's all that's going, and that hasn't been revised in 10 years. And then the 1% is from sports betting, right? And that so far is almost $400,000.
And that cannot be used for, just so I understand, that cannot be used for casino.
I think it can be used for anything. That's the question.
So you'll have the likes of approximately $600,000 a year from now, I should say.
I mean, I would say, we look at risk and protective factors, especially in prevention. So the risk and protective factors are going to be the same, whether it's, obviously young people aren't going into the casino. They may be, doing some online, but, it's the risk and protective factors as far as the prevention side are going to be the same no matter what type of gambling it is. And I guess I would just, so you're right, we've been operating with $100,000 for many, many years, and Lori has done an absolutely amazing job with that funding, and even less than 100,000. And it's nationally known. I mean, we were just at a conference in Arizona, and my staff mentioned Lori, and they knew who she was. You know what I mean? So we have an amazing person, but she's just one person, and so that's what we've had the capacity for. So now that we're getting this influx of funding, like Jamie said, it does take time for us to get permission to spend. And again, we want to be thoughtful about what we're doing because this is new. So we have to increase the capacity of our workforce. We have a prevention structure where, we're covering the state of Maine. And again, the risk and protective factors for gambling is going to be the same as, substance use prevention and a lot of other things. So we have a network of prevention professionals in the field right now, but they haven't done gambling work yet. So, so we have some time where we need to spend some time, getting our field ready to address that. And then if we want to perhaps offer some funding to our prevention providers, that's going to have to go out to RFP, and so that takes some time. So, we know that there is some need right now, and we want to be able to act quickly. We'd love to be able to spend this money right away, but that's just not necessarily how state government works. And again, we want to make sure that what we're doing is going to be the most impactful, is evidence based, and we have a real opportunity to make a difference with this type of funding that we don't often get with some of our funding. So I think, under Lori's, direction, I think, she's really going to help guide us into, I think, a really terrific program with this new funding. But, I guess I would just ask, know that we are working on it. We are mindful of it. We are working on a plan. It's just not going to happen probably within, we need at least a year to know, what we're working with, because we can't put it on RFP with potentially we're going to have, 300,000. We need to know, we can pretty much count on 300,000 a year. Now we can put on RFP. Generally, they're 5 years, so we need to kind of have a good sense of what we're getting before we can really start, offering that money out outside of our contracts with that here in 211.
And just to make sure I understand this follow to Chief Marr's statement, the buckets aren't separate. They'll, it's not 98,000 for casino assistance and the 400,000 for sports. Everything goes into the same ale, if you will, and can be used.
Well, they go into two different buckets, but
But you can dump them
yeah,
out
we can
together.
cross pollinate the buckets. Yes. Yeah, and one of the things I do want to note too is, so we know that there's an immediate need that's growing, and so that's why we've directed other revenue that we have toward this in the meantime of making a plan for how we can responsibly spend the other increases that we've received. And we have seen some increases through the promotion of online sports betting going live. People have become more aware of our services in general, so we've seen an increase in folks using our services. Probably Lori, definitely Lori can speak better to that than I can, but we have seen an increase in folks utilizing the service just due to the increased awareness that came as a result of the online sports betting going live.
So what do you think is a timeline or where we'll know exactly how all this money is getting spent?
So we'll get our fourth quarter transfer in 3 months. And then that will give us a good sense of, right, this is what we can expect in a year roughly. And we've already been doing research to figure out what programming we want we think will be the best fit for Maine. So then once we have that, we'll initiate a financial order and we'll release an RFP for if there are things that can be added to our existing contracts, excuse me, that are within that scope of that agreement, we can add those funds as immediately as things function in government.
And then there's an annual report, look at the fund statute. Where can we get a copy of that report?
That's online. It's a report that we have to provide to the BLA committee every year. So that is available online, but we're happy to send you, email you the link.
Because I looked at it and I was sort of surprised. The report says it has to describe collaborative efforts between the department, meaning health services, and us, the board. I haven't heard from you all in 4 years that I've been here. So I don't know what the collaborative efforts are, but I'm curious what's in that report because we've never gotten a copy. No one's ever come to this meeting. We hear from casinos directly once a month. I mean, I'll put whatever happened in the past behind us and move forward, but like we have acute needs. And I'm just curious how there's collaborative efforts because by statute you're supposed to. Never heard from anybody at the CDC or the Health and Human Services.
So
So
I think Lori attends every time, I believe. So I think she's kind of our, but
but Lori doesn't work. with the
right.
department.
So we're happy to, but make sure that I attend.
Because our frustration is, we see a problem and then we hear from the unit staff, we don't have the people to handle it. We don't have the money. Okay, well, there's a pot of huge money here. Why can't we deal with it? And now it's, well, we can't spend it yet. I mean, I understand it's not your problem, but it's pretty frustrating when we've got a successful program. Through July, just of this year, there's about 300,000 sports betting. We know there's 100,000 casinos. Like, there should never be the answer to a question. We don't have the resources for it. We do have the resources. You know, and I don't know what the answer is, but that's what we run up against. Almost every meeting is we don't, we don't have inspectors who can process the exclusions on these 2 days. Let's hire some more inspectors. Let's do game sets like they do in Massachusetts, right? The sports books probably at some point, or the casinos at some point are going to open sports books. We're going to have folks in there, particularly on Sundays, betting on sports. That should be a time where we have someone in the casinos. But I guess we don't have the money. Like that's my frustration. The other board members feel. And like we approved remote counseling and paid for training years ago for AGENT care. So like telehealth isn't a new thing. Like we've already done it ourselves. There's got to be a plan, and there's states have been doing this for years. I just don't know why we'd say, let's launch this a product. We know the product is addictive for some folks, but we'll just give it a year before we do anything about it. Like that doesn't seem right to me. It sounds like there's not much we as a board can do about it, but it's pretty frustrating.
I think there's 2 steps that I'd like to recommend. One is that we meet every other month generally, sometimes more often, that we extend that invitation, request that a member of the department join us for these gambling control board meetings, sort of as a matter of practice here forward. And if there is a way that we as a board, I mean, we have our public safety commissioner here, I don't know if there's a role or advice that he might offer, but how can we help get those, get that financial note and that process expedited in the interest of the health, safety, well-being of this industry and its consumers. So if there's any role we can play, I don't think that necessarily form of motion, but in the spirit of collaboration between that statute requires of the 2 steps, I think we should do.
Yeah. I don't really want to wait till next year. There should be a plan in place, advertising, reach the folks where they are. If they need help, how do we do it? if your folks need training, they should start the training now. I mean, we're going into the biggest bedding season where we'll see the most need. We're also hitting an economic point where you can tell there's no free money floating around anymore. There's a pullback, taxes are going up, everything's going up. People are gonna be spending that money that they don't have. I'm pretty concerned about that. We had 15 exclusions at the casinos in 1 month. That's a lot. We're not talking 1 or 2 banners. So there should never be an answer that we don't have the staff, we don't have the resources, because the money's there. So I don't know how to solve that right now, but things gotta be worked on.
And I guess, I don't know if Lori wants to add, but I mean, for their next contract, we have increased the amount of funding that they have, to make sure that there's enough, increasing capacity for the treatment network. We have increased self-exclusion opportunities or places where people can do it. So that sort of immediate is included in that year's contract.
When does that take effect?
That takes effect in October. But we did provide them, like Jamie said, some additional funding to kind of carry them till October to make sure that we don't have to, stop treatment for those that are in it and to provide that additional capacity. So in those, so for the treatment and self-exclusion side, I mean, that stuff is definitely, that is included for the more immediate future, for sure. I guess when I'm talking more about if we're going to do more broad prevention work, that's something that we'll have to, learn a little bit more about. But I think Lori definitely has both the treatment needs and the self-exclusion.
Is it okay if I speak for a
Sure,
moment?
go ahead, Lauren.
So I just, as always, had a few comments. For anyone that doesn't know me, I'm Lori Manson. I'm the Problem Gambling Services Coordinator at AdCare. And we've had the gambling prevention and treatment contract with Maine CDC for about 7 years now. And I am the only person who works on that contract. It was a part-time position until recently when CDC infused some additional money into our contract so that I could go full-time. I just wanted to make it clear, we do already offer telehealth through our treatment network, which are Maine LCPCs and LCSWs who have received additional training in problem gambling, and we do a lot of trainings for them. An average of about, I think, 12 hours a year that we provide to them for free, specific to gambling, problem gambling. So I just want to be sure that we've never turned anybody away who needed treatment for gambling, who reached out to us. I would say the problem is not enough people know about it yet, because what has happened with sports betting is that our treatment network has skyrocketed, but it's not for the most part people with sports betting problems. It's gambling problems in general, lottery, bingo, casino. The thing is, they know about us now, some of them. So we've got to make more people know about us, and that's one of the things we're addressing in our contract that comes up on October 1st. We are putting in some paid advertising dollars to try to get to people. For years, since we didn't have enough money to actually advertise, we just do social media. Well, that's only, well, I would say not just social media, but mostly just social media and print materials, and that's not reaching a lot of people. When Jamie mentioned about the telehealth, what we are talking about is that with sports betting, we're thinking that we will outgrow the main treatment network at some point. We will have too much demand. And there are national groups who that specifically provide only problem gambling treatment through telehealth. So we're looking into maybe tapping into them if we're feeling like that the main network is getting too stretched. But as they mentioned, because of the skyrocketing treatment network costs over the last 2 years, CDC has infused enough money into our contract to last through the end of September 30th. Because I reached out and said, we're at a point where we're going to have to say, we can't afford to pay for treatment for the last few months of the year unless, is that what you want? And they have put additional money in so that we continue treatment without a gap in it. So I just am wondering though, because the self-exclusion thing is a little bit of another question. Because we know we've talked about like a game sense program, but will there be enough money to actually have staff at Hollywood and at Oxford to make sure that there's always somebody there to do a self-exclusion? That may not be the best use of the money. That's something that's gonna have to be a discussion.
Yeah, and I don't know the answer to that, but that's what I'm trying to get out is like, what's the thing? Because so far, right, we don't have August numbers, but through July, sports betting alone is $293,000. So you can bet on 400 to 500 for the end of the year because haven't hit football season. That seemed plenty to cover 2 new people to be at the casinos on those days for the whole of the inspectors, but maybe not. I don't know. Like, I don't know how much it costs for advertising. I don't know how much it costs for the training and the national network, set up the remote. That's what I'm trying to get at is like, I have no details. Other than the $100,000 goes right to ad care, most of it, you know. But you can see what happened. November and December was 90,000, right? When it launched. We're gonna be over 100 this November and December. September and October are massive months, so no doubt 500,000. You know, so you can conservatively guess it's going to be 400 to 500 every year. What are we doing with the money? And then when the casinos put in sports books, right? That's a whole other demographic that's showing up to bet. They're sitting there all day betting, drinking, the whole thing. So yeah, it seems like we should be exploring. Is it hiring more people? Is it doing some outside game sense thing? I don't know what the options are nationally. Maybe it's none of those. Maybe you want to counter what DraftKings does with all their online ads, and you know, I mean, they spend seemingly unlimited amounts of money on ads. But that's what I want to see. Like, I don't know. There's a big pot of money. Seems amorphous of what we're going to do. And then I don't want you to ever have to go back to the CDC and say, we might be running out of money here. You know, like that should be increased. And part of that is, I think if we can get that $100,000 statutory amount increased, or at least tied to any, you know, most statutes with that have some trigger, right? So it's tied to an inflation rate or something, so that at least there's some annual increase. But you know, just looking at since 2014, that 100K is worth like 250 now or something. I mean, you know, so that is something I'll try to do. It's up to the committee, obviously, but and then what do we do with the sports betting money? So like, that's what I just want to see the plans. We're not making the decisions. It just like, that's a lot of money, right?
Well, it's plan and process constantly, and just to Director Green's point, there is definitely a very big demographic difference between the people who are sports betting online versus the casino people. So for example, when we're looking at that nationwide self-exclusion app, I don't think the casino people are gonna give a crap about that. They don't want to get on their phone and do this, whereas that would be very good for the sports betting folks. Similarly, there are apps that will provide counseling in an app. Probably most casino people wouldn't be all that interested, but that would be people sports betting people. So
Yeah.
I think, you know, it's like I say, it's a plan in progress, but I don't know that the end result will be that right away we're hiring like game sense advisors for both
It may
that
not.
would suck up pretty much all of that money.
Yeah, and it may not be. So
Yeah.
like, but you know, I mean, this isn't our purview, but the lottery ticket machines take credit cards now. Like, that's crazy. You can buy them online. Like, all this is coming to a head where you can, obviously you're seeing the increased need, but I just looked at the DraftKings app. They bought a lottery app. So in the sports book, it now has a button to buy lottery. I mean, like, we're going down an
Is that
interesting
Maine lottery?
Yeah.
Yeah. So that's a point to be made, is that zero funding for lottery profits go to prop gambling. And it's Maine's, up until sports betting was Maine's most popular form of betting, so just
Yeah.
throwing that.
Yeah, well, these may be interesting conversations with the BLA committee, next year, but that's all I'm trying to get at is we should never have you needing more, and we shouldn't have any, of our patrons at the casinos not getting what they need. I think we've patched out that problem, but still not fully resolved. Okay. Any other questions on this? All right, well, thank you. I appreciate you being here.
Thank you.
Okay. All right, back on track. We'll fit up these license, renewals. We've got 3 this month. Let's see this first. First up is, table game, distributor license renewal for AGS LLC. And for all 3 of these today, this is not an adjudicatory proceeding. Instead, we're receiving an opinion from board staff supported by evidence obtained during an investigation. We'll also provide the applicant an opportunity to be heard, and the public will also be invited to participate. And time will be allotted for public comment. So is there anyone here from AGS LLC? I would think not. All right, seeing none, I assume you have some questions for us. Okay.
So does any member of the board have any reason, such as personal bias or conflict of interest, that would prevent him or her from rendering an impartial decision in this matter? And does any other person present at the hearing believe that there is any reason that would prevent any board member from rendering an impartial decision in this matter? And if so, please stand or raise your virtual hand, state your name for the record, and state your objection basis for that. And if there are any objections to any hearing proceedings, that is the procedure of this case up to this point, please stand or raise your virtual hand. State your name for the record. State the objection to reasons for that. Take 90-day procedure.
Okay, also for this and the others today, each board member has briefing papers based on materials the board staff relied upon the board's opinion. Those papers are part of the record. The board has access to complete investigation. The mass copies are not available for public distribution at this time, as much of it is confidential, but if you want a copy of the public portion, please speak with Director Champion. He'll get those materials to you. Any evidence such as conclusions of board staff, information, statements made today by the applicant or public comment will also become part of the record. So, seeing as there's no one here from AGS LLC, we'll turn it over to Detective Armstrong today.
Yes.
All right, Detective Armstrong on Zoom.
Yes, I am. Good morning. Pursuant to Title 8, Section 1005, Subsection 2 of the Maine Revised Statutes, the Department of Public Safety is responsible for investigating the qualifications of each applicant before a license or registration is issued and reporting to the board the results of any such investigation. Ms. Megan Rozzo, Licensing Specialist 2, AGS LLC, applied for renewal of the company's table game distributor's license on March 29, 2024. The company disclosed and it was verified that since the company's last application for a board license, there have been no changes to the company's address. There have been no changes to the key executives of the company or any parent or intermediate affiliates of the company. There have been no changes to the ownership structure of the company or any parent or intermediate affiliates of the company. There have been adverse actions taken against the company or any parent or intermediate affiliates of the company by any other regulatory agencies, and there are charges pending against the company or any parent or intermediate affiliates of the company in any state or federal court. The company submitted its federal and state tax returns for the preceding years 2022 and 2023. Those financial documents and other documents as required were supplied to our financial review contractor, Whipfly. Whipfly reported that the company, AGS LLC, appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives for AGS LLC were found to have demonstrated financial responsibility as defined by the rules governing the board. The department has investigated the qualifications of AGS LLC and has determined that it meets the board's requirements for renewal of its table game distributor's license. Specifically, AGS LLC and its principals continue to meet the qualifications for a license set out in Title 8, Sections 1016, 1019, and meets the requirements of Board Rules, Chapter 2, Section 4. Therefore, after my verification of the documents submitted, interviews or inquiries, the financial review by Whitfly, and a final review by the Director Champion, it is opinion of the department that AGS LLC is suitable to be continually licensed as a table game distributor in the state of Maine.
Any questions for Michelle?
Just for Chief Archer, just for point of clarification, Don, to make sure you see there are or are not charges pending in state or federal court?
There are charges pending.
There's some civil litigation.
Civil litigation?
Yeah.
That's fine.
Very small part there.
So I do have a question. I don't know if it's for Director Armstrong or Director Champion, but who's ultimately responsible for looking at these citations or regulatory actions and say, okay, it's across the bar? I mean, I understand we get the reporting, and I think they've had contractors, yes, they have reported it to us. The Director Champion, does that fall under your purview to say there's, you're not comfortable with the current or past citations, and there would be a recommendation similar to what we get with Whitfly? Whitfly does financial analysis, but it's you or the AG or Detective Armstrong that does a regulatory analysis?
Well, actually, like with the adverse actions, obviously we can't do anything with charges pending. Everybody sues everybody else. But when it comes to the citation summaries, it's, for lack of a better description, it's part of doing business. And most licensees will gear or stay away from probation, suspensions, denials of licensure, like renewal and all that sort of thing. So they're more apt to settle those adverse actions with fines, warnings, or something of that nature. Because if it were a probation or license denial or something like that, it pretty much has a domino effect with every other state. So that's kind of the explanation for that. So citations, the adverse actions that we see it in every applicant. You'll notice where it's geared more towards, like in the cases where a slot machine or table game distributor, most of the adverse actions are involved in shipments, software not sent correctly, and that sort of thing. But some other entities might have different types of citations.
So are there any adverse actions that would make us say, no, like, they settled, there's something egregious enough in an adverse action? I mean, because it feels like in all of these over the years, we get the report, which is great, but there's no analysis of it. And I think what you're saying is it's just a normal course of business. So unless we saw a suspension or revocation of license, we probably won't comment on those.
Yeah, and that would be the board's decision to review that or to look at it and say, hey, we don't care for this type of activity. And then, of course, you would look at that and what's happening in Maine. All right, so we get quite a few shipments in Maine. I think since I've been here in 2016, we've given maybe 3 or 4 fines or actions against suppliers. So it really hasn't been a lot. But yeah, that would really be more or less for the board to look at and say, hey, we're not in favor of this type of activity.
And if I may, board member, Title 8, Section 1016, instructed to regarding what factors the board has to consider when making a decision.
Yeah, there's more, I feel like we get these all the time, and it feels like it's an irrelevant checkbox. It's like, so what, you have adverse actions, we're not gonna care about them. Particularly, I know we may by statute, but it's almost like the question should read, have you ever had a suspension or revocation? The things that would trigger more denial of our license. That was really all my comment was. Thank you.
But certainly, I mean, hopefully Phil will agree with me. Certainly, if you see a a certain amount of similar adverse actions, we could also table the renewal, and I could reach out to the manufacturers or distributors and have them attend the meeting to answer your inquiries if you'd like.
Yeah, and I appreciate that. It just sort of feels like that's the worst card thing, wherever that works. But that, just like we do a financial review, it feels like it would be the AGs or Detective Armstrong or someone who would pick that up long before it would come to the board.
Yeah. And in my review, I look through these, but they're pretty standard.
Thank you.
Okay. Any other questions? Is there a motion on the application of AGS LLC for renewal licensure as a game distributor?
Second, March.
Okay, any discussion? Need that? All right, take a vote. Start with you, Ms. Green.
Aye.
Chief March.
Aye.
Ms. Bickmore,
Aye.
Mr. Hanslett,
Aye.
and I as well. So results are 5-0. Having met all the requirements of licensing pursuant to Title 8, Chapter 31, AGS LLC will be licensed as a table game distributor in the state of Maine. Of course, we think that we desire to do business in Maine. All right, next up is the application for the renewal of the slot machine distributor license for IGT. Anyone here from IGT? One. Okay. So before we proceed, I assume Assistant Attorney General Matthews has some questions.
I do, thank you. Does any member of the board have any reason such as personal bias or conflict of interest that would prevent him or her from rendering a partial decision in this matter?
No.
Does any other person present at the hearing believe that there is any reason that would prevent any board member from rendering a partial decision in this matter? And if so, please stand, raise your virtual hand, state your name for the record, state your objection, and basis for that objection. Seeing and hearing none, if there are objections to any pre-hearing proceedings, that is the procedure of this case up to this point. Stand, state your name, or raise your virtual hand and state your name for the record and state the objection and the basis for that objection. Seeing and hearing none.
Okay. Seeing as there's nobody here from IGT, guess we'll move on to Detective Armstrong.
Pursuant to Title 8, Section 1005, subsection 2 of the Maine Revised Statutes, the Department of Public Safety is responsible for investigating the qualifications of each applicant before a license or registration is issued and reporting to the board the results of any such investigation. IGT Director of Regulatory Compliance, Ms. Pamela Matthews, applied for renewal of the company's slot machine distributor license on June 13th, 2024. The company disclosed and it was verified that since the company's last application for a board license, there have been no changes to the company's address. There have been changes to the key executives of the company or any parent or intermediate affiliates of the company. There have been no changes to the ownership structure of the company or any parent or intermediate affiliates of the company. There have been adverse actions taken against the company or any parent or intermediate affiliates of the company by any other regulatory agencies, and there are charges pending against the company or any parent or intermediate affiliates of the company in any state or federal court. The company submitted its federal and state tax returns for the preceding year 2023 and copies of its internally prepared financial statements for the current year 2024 as of the close of most recent fiscal quarter prior to application. Those financial documents and other documents as required were supplied to our financial review contractor, Whipfly. Whipfly reported that the company IGT appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives for IGT were found to have demonstrated financial responsibility as defined by the rules governing the board. The department has investigated the qualifications of IGT and has determined that it meets the board's requirements for renewal of a slot machine distributor's license. Specifically, IGT and its principals continue to meet the qualifications for a license set out in Title 8, Section 1016 and 1019, and meets requirements of Board Rules, Chapter 2, Section 3. Therefore, after my verification of the documents submitted, interviews or inquiries, the financial review by Whipfly, and the final review by Director Champion, It is a opinion of the department that IGT is suitable to be continually licensed as a slot machine distributor in the state of Maine.
Thank you. Any questions for Detective Armstrong? Go ahead.
So, Detective Armstrong, I'm a little confused on their application. On number 7, they said no, they have no adverse actions, and yet we have an attachment that has the adverse action. And then on question 8, well, I guess they couldn't decide what they wanted because they answered both yes and no to our charges pending against the company. And we have a litigation document. So it seems like there's some discrepancies in their application itself. And I guess just for the record, from my perspective, there are a number of pending litigations that honestly, I don't feel qualified to say, are those significant or not? It's like they spent a lot of time in court. They've got cases going back to 2015. So I think I'm a little concerned about how the application is spelled out and the litigation. I don't have any comments on that.
I can touch base on that. So we do have a lot. I won't say a lot. We have, on occasions, we'll have applications where people are speeding through them. They do them all the time and they check the box. And then through Detective Armstrong's follow-up interviews with the applicant, he has obviously seen them change their answer to that. So that's why you see in this particular case, adverse actions was added later. In regards to litigation, a lot of this stuff is, I mean, it's litigated, it's lawsuits, can take 7+ years. And so a lot of this will carry on from year to year until they're resolved. So, yeah, we don't necessarily go back in and kick their application back. We'll just ask them to, you know, in the interview process, they say, oh, gee, yeah, we did have adverse actions. And so they would submit them.
Yeah, but that one hasn't been corrected. That's still saying no on their application, and then yes and no on the charges pending. And I guess this is a document of record that we're going to be approving. And if the unit is going to make changes to it, it should be annotated on the document itself that something has changed, that that's not how it was submitted from the applicant.
Well, this was submitted by the applicant, but there were changes.
I understand that, but then there needs to be some annotation, given we have this application, right, on, it says no adverse actions. Yes, we know there are adverse actions. I'm just saying that it's a document of record, and if it's going to be corrected, either it should go back to the applicant to be corrected, or it should be annotated that the unit is corrected.
Yes, we can do that for sure. Yep.
So do you want to table this? Do you want the same application coming back with changes? So maybe,
Yeah, I mean, we know what the answers are now. I just like it's
maybe pending correction.
that's correct.
Okay.
Director Champion, hearing these concerns, are you still confident in your support or renewal of this application?
Yes.
You're moving to approve it pending the update of the application?
Yes.
And that could be an update from the applicant or an annotation by,
To the satisfaction of the director.
yeah. Does that work? Okay. Any issues with that? So Kelly or Joe?
Just clarify, the approval will happen once the director application. To
Yeah.
their satisfaction, that incorporates all the changes.
Yeah. Yeah, and then don't have to come back.
Gotcha. Yep.
Okay, so you made the motion.
I'll
Is there a
second.
All right. Let's take a vote. Ms. Green? Chief March?
Aye.
Ms. Bickmore?
Aye.
Mr. Hanslett?
Aye.
I'm an aye as well. So with that one caveat, having met all the requirements of licensing pursuant to Title 8, Chapter 31, IGT will continue to be licensed as a slot machine distributor in the state of Maine. Thank them for their continued business in Maine. All right, last up is the renewal license renewal, as a slot machine distributor for Aristocrat Technologies, Inc. Pursuant to 8 MRSA Section 1001 et sec. Is there anyone here from Aristocrat? Okay, hearing none, before we proceed, I'll turn it back over to Assistant Attorney General Manis.
Does any member of the board have any reason such as personal bias or conflict of interest that would prevent him or her from rendering an impartial decision? Seeing none. Does any other person present at the hearing believe that there is any reason that would prevent any board member from rendering an impartial decision in this matter? And if so, please stand or raise your virtual hand. State your name for the record and your objection to that objection. Seeing and hearing none, there are objections to any pre-hearing proceedings as the procedure of this case up to this point. Please stand or raise your virtual hand. State your name for the record and state the objection to that objection. Seeing and hearing none, Mr. Chair, you may proceed.
Okay, if there's no one here from Aristocrat, I'll turn it back over to you, Detective Armstrong.
Pursuant to Title 8, Section 1005, subsection 2 of the Maine Revised Statutes, the Department of Public Safety is responsible for investigating the qualifications of each applicant before a license or registration is issued and reporting to the board the result of any such investigation. Aristocrat Technologies, Inc., Director of Licensing, Miss Marguerite Martinez Holston, applied for renewal of the company's slot machine distributor's license on July 29th, 2024. The company disclosed and it was verified that since the company's last application for a board license, there have been no changes to the company's address. There have been changes to the key executives of the company or any parent or any immediate affiliates of the company. There have been changes to the ownership structure of the company or any parent or intermediate affiliates of the company. There have been adverse actions taken against the company or any parent or intermediary affiliates of the company by any other regulatory agencies. And there are no charges pending against the company or any parent or intermediate affiliates of the company in any state or federal court. The company submitted its federal and state tax returns for the preceding years 2023 and unaudited second quarter of 2024. Those financial documents and other documents are required were supplied to our financial review contractor Whitfly. Whitfly reported that the company Aristocrat Technologies Inc. appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives of Aristocrat Technology Inc. were found to have demonstrated financial responsibility as defined by the rules governing the board. The department has investigated the qualifications of Aristocrat Technologies Inc. and it has determined that it meets the board's requirements for renewal of its slot machine distributor's license. Specifically, Aristocrat Technology Inc. and its principals continue to meet the qualifications for a license set out in Title 8, Sections 1016, 1019, and meets the requirements of Board Rules, Chapter 2, Section 3. Therefore, after my verification of the documents submitted, interviews or inquiries, the financial review by Whitfly, and the final review by Director Champion, it is the opinion of the department that Aristocrat Technologies, Inc. is suitable to be continually licensed as a slot machine distributor in the state of Maine.
Any questions for Detective Armstrong? Okay, is there a motion on the application of Aristocrat Technologies Inc. for licensure as a slot machine distributor?
Move to approve, March.
Seconded, hand slip.
All right, there we go. Any need for any debate? Okay, let's take a vote. Ms. Green.
Aye.
Chief March.
Aye.
Ms. Bickmore.
Aye.
Mr. Hensley.
Aye.
And I as well. So having met all requirements licensing pursuant to Title 8, Chapter 31 of Aristocrat Technologies Inc. will continue to be licensed as a slot machine distributor in the state of Maine. Of course, thank them for their desire to do business in Maine. So with that, we will move to unfinished business, which will tie into the inspector issue and review of some of the information we asked of Director Champion. So I don't know if it's you, Commissioner, or you, Director Champion.
I think I'll start, Mr. Chair, if that's all right.
Yep.
All right, well, good morning. Good to see everybody again. I think this is 3 months in a row. My name is Mike Softberg. I'm the Commissioner for the Department of Public Safety. Thank you very much for having me back. I'll give you a little bit of an update since we last spoke. But let me start by just saying, thank you very much for your patience and your willingness to work with us on this issue. We certainly respect your mission, your regulatory authority, your oversight, the very mission of the board, and that you're willing to work with us on these issues. I know it's taken longer than any of us would have liked, so I do appreciate that. I would say as well that since our last meeting, as we left, there was a conversation around, did we pull that rule back from public comment? What do we do? And Milt had touched on that already, the desire to try to retract that. And so when we left the meeting, that was my impression that that's the road we were following, going down. So the week later, after the meeting, we reached out to the casinos as partners. My thought was, it's not in public comment anymore. Let's get to the table with the casinos. Let's talk to them, go through these items line by line. And ideally, that would have happened before, right? Our regular process would be talk to our partners, talk to our inspectors, specifically the casinos in this case, board members in previous conversations, and then you move to rulemaking, and then something is implemented. Because of the legislative mandates to say this thing goes live in June, it was literally flipped on its head to say we're going to implement it here, and then we've got to catch up with all these other things. So change is hard in the best of circumstances, and change is incredibly hard when we completely blow out everything that we normally do process-wise, which I think has led to some of these issues. So I want to say thank you to the casino partners, people that were willing to get together. It was literally like a Friday thing, like, hey, can we get together next Thursday to talk about this? People were going to fly in, they were going to do all this stuff to make it happen. And the AG's office, and I'm thankful they caught this, immediately reached out and said, you know, you're in public comment. You can't have that meeting to work that through. That was the issue, right? I didn't think we were still in public comment. The AG's reminded me that in fact we were, because of the guidance of the Secretary of State. So it made sense at the end of the day that we couldn't get together, but it was unfortunate because really what that means is we have to go back and lean on the rulemaking public comment process, which at this point, 3 times in and heading to a 4th, has been extensive. So there's been a lot of public comment. I say public could be from anybody, but certainly from the casinos, providing direct feedback on these changes. So that's okay. I would prefer to look across the table and say, hey, what do you think about that? But I can't use the magic wand that the chair mentioned earlier. I wish I had one of those to just move away from the rulemaking process. It is what it is. So we move forwards to have additional conversations. The gambling control unit, you know, the last couple of meetings, we talked about the why for the change. We've provided as much information there as humanly possible. We may still agree to disagree on whatever that looks like. We have provided some updated information, however, in this attachment to further justify some of the data that we used in making that decision. But for today, we do have 10 different attachments, and I can walk through those. I'm going to lean on Bill for some of the specifics. But we went into the rule itself, right? And we pulled out some items that involve notification of the inspectors at one level or another. And provided some tweaks to that language to facilitate what would that look like now? Who do you call? What do you do? And if this thing happens to happen or happens to occur? So we kind of walked through this and provided a bunch of information here. I'll touch on the attachments themselves. Number 1, this was just the rules themselves. And that's just a word search that Milt conducted. The chair had asked for some titles to attach to that, which makes perfect sense from a tracking standpoint. So that would be document 1, just as the rules themselves that are impacted by that notification to inspectors or an inspector supervisor. Attachment 2 actually includes some changes to that language, to that verbiage, to allow for the casinos to know exactly what the rules are moving forward in that new rulemaking package. I will also say this, that I met with Milt yesterday, and that the rules that you received last week, the language that you received last week, essentially pulled inspectors out of there 7 days a week and said, just go ahead and send it right to an email address. And I think that went too far. I think that's miscommunication on my part. to Milton. So really what we want to do here is leave the existing processes in place 5 days a week. If their inspectors are there, they're a major important piece of this process. They're incredibly strong partners. They are subject matter experts in the facilities. So we want the casino to use them and use them accordingly, which would mean make those notifications those 5 days a week. The extra 2 days that we don't have physical coverage in the facility, Sundays and Mondays. The intent here is to say if they're not on duty, then you just email 2 of those addresses, whether it's the gambling.control one or the director specifically. So I think that covers us 7 days a week, right? Because we've already had a scenario where somebody was out sick and their partner, even though we had 2 people, was out on vacation. So in that scenario, this would provide guidance across the board. It'd say if there's not an inspector there for whatever reason, this is an option for you to move forward. Some of these other scenarios also include, I think, updates that are important and necessary. And we'll walk through these individually if that's the desire of the board. But the 3rd and 4th documents, those are comments from Hollywood and Oxford reference to the inspector schedules and how that would impact their work. I think we've addressed those questions or concerns either in the rule component or in the 9th document that I'll get to in just a second. Attachment 5, completely valid question. We were utilizing 2019 data for coin-in information, play-by-hour stuff. The information that you have in here under attachment 5 is 2 weeks old. So it does mirror the information from 2019, but we should have had the latest information for you, which again shows Sundays and Mondays being the slowest timeframes for coin-in or play. Attachment 6 looks at the history around violations or formal violations, and that's from 22 to 24. So it lists those, that's all on one page. There's a total of 24 formal violations. 19 of those are self-reported. 3 of those are shipment issues. 1 of them is a patron complaint. And 1 of them is initiated by Deputy Director Motti recently. That's the last one under 24 for camera placement. Attachment 7, that's the jackpot payout stuff. Good conversations around that during our last meeting. So this is very specific information around when these jackpots come in. And as the chair noted, and everybody certainly would concur, these are random, right? It's not like it's going to happen on a Sunday, it's going to happen on a Wednesday. And there are some existing language there around discretion for outlaying those jackpots as they come in. That's currently in the system. Attachment 8 discusses shipments since January of 24. And that would be 42 total shipments since January. 1 of those occurred on a Sunday, 1 of those occurred on a Monday. And document 9 is information built into the basis statement by Milton. So when I said that information or questions, concerns from Hollywood and Oxford reference to the schedule change was either implemented in the rule component or in this final document, this is where that comes into play. So there's some questions and some responses there in red under attachment number 9. And then attachment 10, which I think is also incredibly important and necessary, is that we clearly have a break in time here between or during this transition from the existing rule to whatever ends up as the final rule months down the road. That's something that we can try to streamline as much as possible, but don't control the timelines under the rulemaking process as it currently exists by statute. So that attachment 10 is the resolution number 16, and it's 16 because the board currently has 15 others that I'm sure you're aware of. But this is a resolution that essentially talks and formalizes, it puts in black and white, it puts in writing the grace period that the director has discussed in the last couple of meetings verbally. But if I'm a casino, if I'm a partner, I want something in writing. If I'm the board and I have oversight over something, I want to know what you're going to do in the meantime. The current rule is in, we're waiting on a new rule. What do we do if tomorrow or next Sunday for that matter, something happens that would currently say you have to notify an inspector. We're like, hey, don't worry about it. We understand each other. Well, this codifies our ability. It puts the grace period in black and white to say, if that happens, then we're not going to move forward from a disciplinary standpoint on that specific aspect of the rules. So if you're supposed to contact an inspector or an inspector supervisor on site if an issue happens, then essentially it's going to be able to email the director that information real time, and then we'll deal with it from there. So we thought that was important. One, I wanted to make sure we brought the inspectors back into that language. That was not the intent to keep them 7 days a week. That's not what we wanted to do. So that's on me. And then we also wanted to make sure that we were providing some guidance, reference to our specific guidelines for discipline. Call inspector, I can't call inspector, inspector's not here. Okay, we'll refer to this with resolution 16. Contact that email, but you're covered on that end. And make sure that we were clear about that, again, with our casino partners. So that's a very high and quick overview of those 10 attachments. I'm here for you, so happy to answer any questions or give that a attempt.
Thank you.
One overarching question. When are the inspectors not there? What are those hours? Is it all
Well, that's
Sunday?
specifically,
Yeah, well, they're not there, Mondays, Sundays and Mondays. And, aside from that, I believe Hollywood is 8 to 12 and, Oxford is, I believe, 7 to 2.
Okay, got it.
Thank you. So before we talk about rules, I just want to circle back to the root cause of this, which is not having inspectors there. And point out that in the current data that you
Yeah, I
provided to
was gonna
us.
ask, because I'm colorblind, but it looks like
Yeah,
Sunday.
in the
is pretty
current
busy.
data, point by play, Sunday is the second busiest day of the week. And if we look at the jackpot, it is as likely or more likely that the jackpot will be on Sunday or Monday. So I would suggest that the current data that you provided to us doesn't distinguish that Sunday and Monday are these quiet down days. And we also believe that Sundays will get busier in the casino as sports betting eventually comes into the casino. So I guess, to me, I'm still back on the root issue of why we don't have inspectors Sunday and Monday, and I don't think we provide the data provided that supports that yet.
so I think that the jackpot component to this is there's already information in the rule. There's already language in the rule that allows for discretion for them to do that, no matter what day that is. And I'm not sure that data specifically says, well, we're going to have more hits on a Sunday than enough, because it's supposed to be random. And I
It's only
believe
random, but if you look
The
at
more
it, right,
player.
it's equal. It's
Yeah.
as likely or a little bit more, just
Sure.
on the base of the data. And
Yep.
you keep coming to us and saying, the data shows, and so does Dr. Champion, the data shows it's quiet days, you don't need inspectors there. I mean, if there are other reasons to not have inspectors, we don't have the funding, we can't find inspectors, well, then let's talk about those. But we keep saying, or keep hearing, it's being data driven, but the data doesn't support that.
But you want to touch on the coin in data from 2024?
Yeah, I mean, it basically just gives the patron play. Obviously, if you look at the chart, if you look at a Sunday, most people are getting out of church by noon. And the most play in Hollywood is from 1 o'clock to 6 o'clock because everybody has to go back to work Monday morning. A little bit different, but not too much different on the Oxford side. Again, the most play is between 2 and 4 o'clock in the afternoon after church, for whatever reason. And then it kind of dies off from that end. Monday is a lot lower, obviously, than Sunday. But just looking at that was just to give you as much information as I could give to the board in relation to, patron attendance and all that sort of thing. So.
Yeah, I think just what
that's-
stands out is, Monday and Tuesday are slow. Sunday is anything but slow.
I mean, and again, it gives you an idea of play, but a patron's, I don't know of any patron that's ever said, oh gee, I'm not going to the casino today because there's no inspector. I mean, this is driven by them wanting to play, them wanting to participate, not
But that's not
necessarily,
the issue.
not necessarily what.
We're not talking about what is driving the consumer. We were told months ago and repeatedly that the decision to change the schedule based on data, that there wasn't a need for them those 2 days, and the data does not support that.
As well as the feedback from casinos.
Well, so when we took this from central monitoring to facility based, right? We relied solely on Light and Wonder, previously Scientific Games, to monitor service, assist in the service of the slot machines on the slot floor. That has changed now to where a director, through a work order or wherever, when they want to make a machine move, or they want to upgrade, or they need software verified, and all that sort of thing, an inspector has to be there, like central monitoring system was always available. So the rationale was the previous schedule had one inspector on per shift. And if that inspector called out, they had to change the move, and they had to rearrange their schedules, and the delivery couldn't be accepted today, we'll have to accept it tomorrow, and all that sort of thing. So in the interest of them or us creating a customer service to the facilities, I just felt that it was better to have two inspectors on. And like we had a couple of weeks ago, one inspector was on vacation, the backup inspector called off sick. So we didn't have an inspector for that particular shift. But as these things come up, it's less likely with two people scheduled versus having one person scheduled. Plus the fact when the prior schedule, if that one person didn't show up, they were out for 10 hours. And now if they don't show up, it's 8 hours. So at least it gives that little bit of a change. But that was the rationale around that too.
I don't know that you've ever heard us say we don't need inspectors on Sundays or Mondays. I think what we're saying is that you do a workload analysis and you look at that, and that's one component. And then if you look at shipments, you look at violations, and you look at this other information as well, that they're saying that that's happening on different days of the week.
Yeah, respectfully, we have heard it a number of times.
Yeah.
That Sunday, Monday were not necessary for slower days.
Mhm.
And respectively, the data still doesn't support that, right? It's just as likely that any of these things happen on Sunday or Monday than Tuesday, Wednesday, Thursday, Friday. And I know you guys have comments too. I just don't get this. Why we don't need inspectors? I have a really hard time believing that. And the argument of I need two all these other times, but I don't need any 48 hours or more, but at least Sunday and Mondays.
Well, I think what doesn't,
Right.
we're not gonna relitigate this the same every month though. There's an off chance that somebody's sick and then we don't have money, which happens maybe a few times a year versus 2 days a week, every week. Like that just doesn't add up. And I guess that leads to the ultimate question of, with the proposed rules, why do we direct the casinos to do something 5 days a week and not the other two? Like, what's different about those 2 days? If there's a need that, well, the inspectors are vital to this, pick any one of these on Tuesday to Saturday, but they're not Sunday and Monday, why should we make them do it?
Why have inspectors?
Well, I think when you look nationally, there are states that don't have inspectors. And it runs the continuum from, they work days, they work 24/7, they don't have them at all. It runs the gamut across the board. Those are other states, that's not Maine. It'll depend on what your desires are. But I would say that what the attempt here is to do something well for those 5 days and provide extra coverage, to provide that there's somebody there. And when you look at the specific rules themselves, I don't think that it's some massive swing or change to say, well, if they're not there for whatever reason, contact this email address, and it negatively impact their work in the sense that they can continue on. They're not shutting down, entire areas of the casino or otherwise. We're saying we can provide a more extensive service those 5 days by guaranteeing that we'll have people present. And those 2 days, Sunday and Monday, where we don't have anybody there, that they can continue to do their work and just contact the unit and they'll address those things and forward those or deal with them as they come in.
So, I mean, I guess that gets also the question, was this just to save money? Like, who was pushing for the change? Because I think we have the same number of inspectors, right? They're
We do,
just-
yeah, we do.
So why, like,
I think the change is to the central monitoring system to facility-based, and there are additional things that come into play with facility-based. And the idea was to try to give them as much coverage for those 5 days a week for the facility-based system, which was entirely new to everybody. And we thought that, and that may change down the road, to think that we get into this a little further and then realize, well, that schedule doesn't work. And this is why, because we have more information that says we're having issues on Sundays and Mondays, and the rule changes that we have in play aren't working. We've got to fix something in order to work with the casinos and help facilitate that change. So the change itself, saved a lot of money on that end of it for the central monitoring versus facility-based, but the staffing levels were intended to provide excellent service during those 5 days and make sure that they can continue to do their work on the other 2. That was the driving. There's no, I think that there's some kind of an impression, like there's something behind the curtain here. Like, this is why this happened.
yeah,
It's
it
not.
just seems odd, right? It disrupted a lot of people's lives, made a lot of people angry. And I guess with a promise of, we're gonna do better 5 days a week and then do nothing 2 days, like, it doesn't add up, but it is what it is. Just, like, was the service subpar 7 days a week? So now we'll just ramp it up for 5 and do nothing 2, like, it's odd, and to say that, well, the casinos just notify now, there's no difference, like, well, if a machine malfunctions on Sunday, they gotta wait till Tuesday for it to be cleared. That's what it says right here.
No, they don't. No, they don't. They can,
It says, protect the slot machine from any further play, will not be cleared until approved by the department.
that's in regards to a malfunction with a jackpot. If a jackpot hits, they go out to the machine and the jackpots or the printouts read out a 250,000 jackpot. They look and it's only supposed to be 25,000.
That's not what this
So
is.
that machine's malfunction.
Pull up the rules. 2F, machine malfunction, patron disputes.
Right.
That's not about jackpots. That's a separate section.
Right, but it's inadvertently a part of the jackpot feature, or it could be just when we have malfunctions where the wheels keep spinning. I mean, Eric could probably give you
Yeah,
10
but
different.
that's my
so
point. So if it happens on a Sunday,
They
they
can
gotta,
correct it, and then we come in on a Tuesday and we verify and seal up the machine.
nope, but this says that the slot machine shall not be cleared until approved by the department. So how does the department approve that on a Sunday or a Monday?
I'd have to look at that section a little bit more. I
This
think
was
it's-
your proposal to us.
Yeah.
So one slot machine is down in your example, and that is
I'm just
what
asking,
reason to not do
this is-
any of this?
this is the document you gave us, which apparently was not reviewed. And that's just one example, it's on the first page. Right? So I'm just asking, like, this is being pitched as, this doesn't change anything, all I gotta do is send an email, we're good to go. That's not true, because, I mean, I've been in casinos when there's an issue. Sometimes it's software, sometimes it's mechanical. And you're gonna tape it off for 2 days. And in the likelihood of that happening, let's say it's 1 or 2 times a year, is only nominally different than the likelihood of having all these multiple call outs from inspectors on the same day. Like, we're talking about probability here. So I don't know. I just, every time we talk about this, there is like a bizarre land. But this is what's proposed to us to adopt.
Yeah, and I mean, this is specific to machine malfunctions. Now, I don't have a description of every type of machine malfunction. But when it malfunctions and they can't correct it, yeah, you wouldn't say, oh, well, just let the patron continue to play. They would take it out of play And in some areas, we have to go down to the third paragraph and get forensic laboratory examinations. So, but these are,
Okay, but if the
Extremely.
casino says, we fixed it, we're comfortable, put it back up. They can't do that, because it says it has to be approved by the department.
they can ram clear, put the columns back up, and then we come in after the fact with a work
This
order.
doesn't say that in the rules. That may be your interpretation of this. The rules that you provided to us, it doesn't say that.
It's okay to say that, okay, that rule doesn't say that, then let's try to fix that, then that's okay.
But,
That's
but
all right.
Commissioner, we're being told it doesn't say that by who proposed these. So what am I approving? Because the English language says to me, this is what it says. I'm hearing, no, that's not what it says. We're being asked to approve it. So I don't, overall, I don't think the changes are that dramatic.
Would you like to go through those one item at a time and then look at those, or?
No, I guess just the question is, what's the, it's up to the rest of the board members, of course. Do we do something different 5 days a week than the other two? Or just make it uniform?
Personally, I don't think the case is ever made for it.
And again, if I may, this is all recommendations. I mean, the board is the ultimate decider here. So all I could do was, this is nothing personal, based on my experience, based on pulling data. I mean, docket numbers, most of this stuff is self-reported, which casinos, both facilities have to do by statute. And so a lot of our violations are being found self-reported because, as a matter of fact, an inspector may not be standing right next to a dealer when the dealer has an infraction, or they might not be standing next to a slot attendant who's doing something with a slot machine, or, any of those. Now, they've obviously been involved in the shipping issues here, okay? But this is just to let you know, Mark, majority of the formal violations are self-reported. And then, jackpots are jackpots. They're going to happen anytime, all the time, no matter what. But jackpots are paid out at the discretion of the facility. Shipments, I mean, the one shipment on Sunday, I verified was supposed to be delivered on a Friday. But this is just to give you more information. But yeah, ultimately, the board makes the decision here. But I just wanted to give you as much information as I could and explain that, with one inspector on duty, and if Eric can't get 10 new, we have new small distributors coming in. AGS is applied. If they want to come in with 20 machines or 30 machines next week, we have them scheduled to be on a Wednesday or a Tuesday or whatever. And I have an inspector call out and I got to tell these guys, now you're going to have to wait 2 or 3 days to put your machines in. I mean, so, and that's deliveries. Now we have the day-to-day work orders, which is, okay, this machine went down, the comms went down, we ran clear, we fixed it. We just need the inspector to go in behind us, check it, tape down the CPU, and life is good. So there's those, processes that I think have to be, that should be done in a timely fashion. So that's really the rationale. But again,
I feel like
it's
you just made
entirely.
the argument for why I would have inspectors 7 days a week, but I guess what I'd like to hear from you, Dr. Kemp, is what do you see as the primary role as the inspector who's on site?
Well, the prior board used to say trust but verify. And my philosophy has always been, because I came from the industry and I developed many internal controls, policies, and procedures in my lifetime. And my philosophy is, tell us how you're going to run your business, and we'll check on you. I don't think we're here to, all these slot techs are highly trained individuals. IT, Matt, our deputy director's been working with the surveillance technicians and stuff. All these people are really good and dedicated at what they do. So we just need to allow them to do what they do and just come behind it and check on them, really. I mean, it's no different than a electrician. inspector, right? When you go and put new electric in and the state inspector comes behind you, verifies that all the electrical is put in there, but he doesn't stand there and watch the electrician do all the work, you know what I mean? So hopefully that's it.
So why not have a floating staff of inspectors who are located here, and when they need somebody, they go off to the casino?
In some states, that does happen, yes, some states. I'll tell you, in a lot of states, having opened up facilities, everybody goes in full bore and has all these people running around stepping over each other. And then over time, it relaxes. A good example would be Atlantic City. They had anywhere between 8 and 10 New Jersey State Troopers in every casino. Now they're out of one little office on Atlantic Avenue, and they get called, they dispatched each other. So it's growing pains because we're not really sure how things are going to work out. And so maybe this is just one of those.
Do we have insufficient staff of inspectors? I don't have benefit of history of these two meetings. Do we have insufficient staff to cover 7 days a week, even with staggered days off? I mean, there's a staffing question.
No, we've had 9 since I've been here.
Was that sufficient or insufficient?
Yeah, we've had 9, and it was just a matter of changing the schedule time. Yes. I mean, and honestly, our inspector supervisor, while it's not assigned specifically to either location, she's also available and goes to either one of those locations on a Monday as well. So, not to say I want to push any more, an inspector's job onto the inspector supervisor, but we do have at least a partial of a Monday coverage at one or both or either one of the facilities currently.
So, Mr. Chair, from my perspective, and I believe several of the board's members, the underlying question here is whether or not the board would require 7-day coverage versus 5. And if you don't believe under your authority and for oversight that a 5-day-a-week schedule is sufficient, then I just need to hear that point blank. And we'll try to figure out what we need to do to fix that otherwise. I'm not here to frustrate you or to work against you in any way, but I can only provide the same information so many times and tell you that this is what the reasoning was. That reason doesn't work for you, and you want to see something different, then we should discuss what that process would look like. I think, that's only out of respect for your time and everybody's time. If that's the underlying question. If we're not on the same page there, I can tell you whatever I want. PowerPoint this thing to death, and we could do it all day. But the reality is, if that is the question, and you are not comfortable with that as a board, then I need to know that. And then we can determine what we're going to do from there. There is no, behind the curtain thing going on here. My subject matter experts were looking at this. They were trying to do the best they could to provide service to the casino. If you disagree with that and would like us to go in a different direction, then just tell me. And we'll try to figure out what that's going to look like, moving forward. That's the reality. That's the core that we have here. And I'm, again, I don't want to beat around the bush and waste a bunch of your time. We put a lot of time into responding to these questions because that's what we're here for. You are the regulatory authority. You provide oversight for the mission of gambling in the state of Maine with casinos and the stuff that you always talk about right at the beginning of these meetings. So we are your arm in many ways to facilitate that oversight.
Yeah.
And we've done what we thought we should do.
This
If
is
you disagree,
this
let
is
me know.
new to hear because the whole change happened without us knowing.
Well, and I think, as I mentioned, this whole thing happened completely different from how we would normally do things. And I agree with you completely. That's not the way to do business. That's not treating you as a partner in that regard. There's a deadline. We got to try to get something done, and we made a move. If we disagree, then I apologize for that.
And if I may add to that, I was prepared to bring the schedule to the board and was advised by legal that it was a department decision, not necessarily a board decision. So that's why That's why.
Yeah, so I don't know
And
if
this
we
was all
snap-
done- This is all done in collaboration with HR and all that as the commissioner.
Yeah, I mean, so we say today, no, we want inspector there whenever the casinos are open. I'm not even sure that can happen because there's a union to deal with. There's, this is the first I've been invited to even make that decision in several months, because then my understanding that the department decision. So I don't know what the answer is.
I think there's a difference here. I think from a personnel standpoint, boards they're not involved in personnel matters. However, you have a statute that dictates what you're responsible for. I'm the least attorney-ish person in the room, so I would look to somebody else for that answer. Phil is here, without backup
Yeah,
today.
I mean, I think the revert, the flip side of that is, if, it almost seems like we don't need as many inspectors. That got someone centrally located and they go out as needed and everything else is sent by email. Do it that way. I can see that side of the coin too. So I don't know how the other board members feel, but if we don't need them 2 days a week, I don't know why we need them the other 5. That's sort of what I'm leaning. Maybe I'm reading that wrong.
I don't understand it. I don't understand why we'd have gaps if we have staff for, not 24/7 clearly, but somebody on each day that each casino is open.
Yeah, if what they're doing is sort of spotty based on these specific things that can be scheduled, like a shipment or whatever, why do we need them? Have them sit here and they go out as needed.
Well, I think there's aspects of this where they are monitoring table games real time. They are,
But if they're doing that, you're saying it's not important for them to do that 2 days a week, so why do they do it the other 5? That's where it doesn't connect, because I think that's what Ms. Green was trying to get at, what's their role? If the role is to be the state's eyes and ears, casinos operating, because I know plenty of examples, right, where casinos do things that they wouldn't like, not here in Maine, but elsewhere. Right, because the state has a financial a big financial interest in making sure everything's above board, every coin is counted, all that. So if inspector's role is to be the state's eyes and ears, they should be there whenever those games are up and running. But if it's not that, then that's a different role. That Sundays and Mondays, we don't need them. Why do we need them Tuesday and Wednesday? That's okay, let's really save money. If we're gonna go down.
well, just so I'm abundantly clear to the Zoom recorded world, there was never our intent to reduce the number of inspectors across the board. That was not our intent. That was not some mystery.
Yeah, no, it's not
I
your
have a
intent.
mandate deal. I also want to say out loud that from a workload analysis standpoint, the argument that you just made, Mr. Chair, that if I've got 30 Portland police officers working on a Friday night at 9 o'clock, I should have 30 working at 4 a.m. on a Saturday morning, because if it's all equal, it's all equal. And we can't do this with less, but you
Well,
do
no,
workload
because-
analysis all the time to say we need more over here than we need over there.
That
That's
would
just
only
the way
be
of the world.
true if Saturday morning had a very similar call load as Friday night, because your data tells me that Sundays are second. Right?
So what
that's a
about
difference.
Monday as an example? So Monday, you would say what?
Well, but that's determined on the roll. So if you're saying this is just about workload analysis, then yeah, I think there's consideration of maybe it's Monday and Tuesday that are up. That's what's never made sense to me, is if it's solely about workload analysis, being able to deliver the best service, then maybe the 2 days off are Monday and Tuesday, not Sunday and Monday, because the data doesn't support Sunday. That's where the gap is. And look, there's obviously nuggets of something going on with all the complaints that we've received in the media. Some of it we can't get into. And that's why I feel like this isn't enough. So if it's solely about workload analysis, then your police analogy falls short. Because if you told me Friday nights are the busiest, and your data told me that Sunday mornings are the second busiest, and I'd say, yeah, you probably need 30 of both. That's what the data shows me here. So maybe it is that change, but I guess what I'm looking at is here's all the things that inspectors on site were supposed to do. We're shifting that for 2 days a week to just fire off an email. So if it can be accomplished to the satisfaction of everyone by sending an email 2 days a week, why can't you send an email the other 5 days?
I would say this, that. So if we said, okay, then we'll do Monday, Tuesdays then. I'm still hearing that that's really not
Of
the core
course.
issue here.
Because
The
this
core
whole-
issue is whether
of
they
course.
should have 7-day coverage or 5, and I haven't
course.
heard an answer to that yet.
Because despite your intent, what this has uncovered is my thought was inspectors are supposed to be there whenever the casinos are operating such that they're the state's eyes and ears. But what I'm hearing is that's not true because we can get away with not having them here regardless of what 2 days it is. So this has now led me to look at it over the past several months and think, oh, maybe we don't need them, right? Maybe we really don't need them the other 5 days. Because of all of these things, 3 pages of things can be accomplished by firing off an email. What's different between firing off an email on Monday and not using the email on Tuesday? There's no difference.
Well, the email notifications is only prep work for what they'll be doing on it.
Sure, so they send an
You know.
email and then you schedule that inspector.
I mean,
You're in
I
Oxford
get,
today,
I get
you're
the
in Hollywood.
emails, I get the emails now, notification of a jackpot. I get an email, calm down, ram clear this machine. It's not like a whole lot of activity,
Yeah,
and that's right.
I know
And
that,
and I
I'm agreeing with you.
apologize because I try to give the board as much information as I can. Coin, pay and play has nothing to do with inspector coverage. I mean, just because it's busier on a Sunday than it is on it, what triggers an inspector is what happens while that play is going on, So,
Which
um,
for the machines would seem to be random. So you would need someone there when they're operating because it's random. And the workload analysis falls short. I'm hearing both sides coming out.
Yeah.
There's no consistency, and that's where my frustration is coming from. But all of this, whether it's the intention or not, has shown me we actually don't need inspectors to be there all the time. That we can schedule the stuff that needs to be physically scheduled, send them out, do it that way. Like,
So-
I think it's a net positive. This stuff can be accomplished by just sending off an email. Great. Now you have extra personnel. Just train them how to do rulemaking. Just train them how to do other things. Because I'm always hearing there's not enough personnel. So we'll get them in the office. They'll start doing the other stuff. And when they got to go out for a shipment or they got to go out, maybe we do it that way. Because if they're not necessary 2 days a week, they're not necessary 7 days. Sorry, don't see it that way. Other board members can feel that.
That's been my position the entire time. You don't need them 2, why do you need them 7? I look at them as our eyes and ears, so I would.
Well, that's what I thought their role was, but I'm hearing that's not their role.
But that's what I've said since the beginning of this discussion way back, is I don't understand the difference between 5 and 7. And I hear the customer service argument, that reasoning, I do get that. And I appreciate the consideration, but, so I guess I'm no further along in this at the beginning. Very ambivalent about this.
We, as a department, I will tell you that I support having inspectors in the facility. I'm not doing that to our people, and I'm not doing that to that system. I think they deserve better than that because I do think that they provide an important service. I, however, would disagree to say that I do think there's a way to look at that 7-day week and cut that pie appropriately based on information that we have in front of them. You may disagree. I'm not hearing, I don't think you tell us shouldn't have any inspectors in the facility. I think you look at your mission and you say, this is how we interpret the mission. It should have 24/7 coverage the entire time, or it doesn't need that. It doesn't need people in general. You go forward and figure that out operationally. Operationally is what we would deal with to try to do that. Because this process got flipped, we didn't have that guidance on the front end. It was try to figure out how to implement this thing and do it to the best of your ability. So I'm asking for the feedback to say, how do you interpret your mission and how we would do that? I'll go forward and try to operationalize that. What staffing levels are and personnel issues, I don't believe that's a board thing. There's a piece of that that's cutting hairs, right? We're cutting hairs to say, what's your mission and how do you want us to do that? And then we come back and say, this is how we're gonna try to do that for you. But again, Phil, does that make any sense?
It does, and I appreciate it. So correct, the board's duty is of course to enforce the provisions of chapter 31, title 8, and any of the rules adopted thereunder. The unit is, or the department is there to carry out the enforcement mechanisms of the board to ensure that they can enforce the provisions of that chapter. The board can express concerns regarding the ability to enforce this chapter because of units, maybe staffing levels or the schedule. But of course, you know, there is a point where the board's power is not there in terms of saying we need this many inspectors on, or this person should be hired. So that's not what the board does. You know, there's also labor considerations. However, you know, looking at a remedy here, just trying to delineate some sort of legal remedy here from the board, then is that correct? I believe the board could potentially, as an example, create a resolve noting that they would like to see as practicable, considering all of these hiring concerns, staffing, you know, hurdles that may be in place there that's outside of the board's purview and the departments at that point, that they would like to see duty inspectors at least for that 5 days or at the busiest time or something like that, showing some contour that they believe that they will fulfill their duties under chapter 31 because they will have a certain level of inspectors on a certain period of time. So certainly a resolution could show the unit what the board would like to see, you know, in more of a forest than a trees sort of viewpoint.
Thank you, Phil. I think the framing a resolution of the intent of the interest of this regulatory body to have at least the availability, if not in facility on call, each day that a casino is open in Maine, and leave that operational logistics and even requests for need for support for additional staff to come to this board. If that's what's required, because there are insufficient numbers. But that's not operational, that's a labor issue, that's a executive function of the commissioner, his management team.
Well, so what are your thoughts?
Just to make sure I understand, you're suggesting the resolution is either there's on-site inspector or an available inspector, right? So someone could go there, someone's here and could go there.
I would suggest maybe presenting the language prior to the next meeting.
Yeah, I just
Trying
wanted
to
to-
work on it because there's a lot.
To me, the other part of this, and I wasn't gonna bring it up, but Commissioner, you brought it up for the third time, so now I feel compelled to, which is, I realized that there was an abbreviated time frame between central monitoring and facilities monitoring, but it wasn't overnight. It just didn't magically happen the next day. So I'm really uncomfortable with the fact that we have to retrofit everything and the constant reasoning that it happened quickly. And I just want to make sure that going forward, even if there is an abbreviated time frame, even if we have to call a special meeting, which I'm sure Chair Stover would do.
We've done it before this year. We've done it this year.
Yeah, that we get involved so we're not in this process of retrofit.
I would agree with that completely, that I want to make sure that this is as harmonious as humanly possible. I do think, and would concur with, Milt was right this close of bringing a schedule to say, hey, this is what we're thinking. And we're told by HR and told by our attorneys that that's not the role of the board. And I think that's still accurate, right? A specific personnel matter, but I think we're looking at it a different way. And I've had a meeting with the AG's office to say, talk to me about the mission of the board. I want to make sure that I get these two things together. And we didn't do that.
But I think the conversation did didn't have to be that. The conversation had to be, because we were told by the legislature to change our monitoring system, here are the ramifications. And one of the ramifications might be how we have to deal with scheduling, not the specifics of it. Whether I agree with factors,
Agreed.
HR, you said it, no, it doesn't matter.
Mhm.
But there were ramifications, there were consequences of that quick change. And I think that kind of discussion would have been very beneficial.
Completely agree, completely agree. That makes perfect sense.
Yeah, so with the rulemaking process, where does that leave us? We need to propose language.
If you wish, yes, to kind of bridge that obligation gap left open by. So there's been some proposed language from the executive director, concerns expressed by the licensees. You know, you could work with the language proposed to.
Yeah, so that will go out for comment.
Yes, exactly. Yep.
My apologies, but we're discussing, let's say you come back with a resolution that says you prefer 24/7 coverage, the rule that you're about to stop at may be completely irrelevant. So,
Well, it may,
because we want to muddy it up a little bit.
it may not because this would at least account for situations where there's not an inspector on duty, given the concerns about folks calling out sick and vacation happening repeatedly, that we wouldn't have somebody on duty. Now the casinos know what to do.
It certainly gets us to the October meeting no matter what, right? Because if we're currently working a 5-day schedule, there's that 2-day gap. We'll see what happens long term. But I think the resolution makes sense because we've at least got an answer for the casinos, our
Well-
partners for the next couple of months.
Yeah, we're not even at the resolution yet. I'm talking about the proposed changes to the rules, which regardless if there's a change made, I think at least give some direction as to when an inspector is not there or whatever. Because what I'm hearing is even if we go to 7 days, there will be instances where there's not an inspector on duty for a variety of reasons. So
Yep.
now everybody knows what to do. Well, seemingly, see what happens to the comments, but, so, you know, I think the changes that were proposed make sense. If others feel differently. Anyone, Joe or Kelly, you've been dominating the conversation here.
I've been listening and I don't have anything to add at this time.
Okay. So, you know, I would support taking the proposed changes that came from the unit, and incorporating that. Put it out for comment. Because I think it helps put a plan in place when there's not an inspector on duty, whether it continues to be 2 days a week for years or just because folks are out or whatever. So I was thinking that. Can we do that as a package?
To vote, to approve that for publication.
Yeah.
You can, and with that, are you republishing? I believe there's some comments for the board to review.
Yeah.
And so you can approve the basis of those comments, then do language for publication. Straight to the question.
So this copy that you received with stuff that was in red, that was the comments from the third publication, which did not include these, or may not, I should say, may not include some of this. Well, definitely has not included it because now it's reworded. So what I would do is if the board accepts these comments from the third publication, I would change the red to black. And the only thing that would go out for the fourth publication would be this material here. That's right. Yeah.
Yeah, I mean, basis statement seems fine to me. I know that it doesn't there are plenty of instances where, comments are sort of accepted, changes are made. There's a few where they're not. I'm okay. Some of them are pretty technical things, so we would defer to the unit.
So
Okay, Phil, were you able to try to summarize what we just,
So,
so we'd be adopting?
from what I understand, you want to approve the the responses to the comments. Okay. Thereby, the final version of the rules, before, not really final, but the version that won't be disturbed by a board publication. That board publication will focus the comments on the duty inspectors.
Yes. Yes. Okay. So that would be a motion to do exactly.
A motion.
So moved.
A motion to approve the responses to the comments for the third publication. And I would maybe do a second motion to it.
Okay, all right, so we'll approve those comments. You move.
I did.
Can I just ask you?
Yeah.
Whose comments are we approving? Our comments or the?
Correct.
So you see there's
Our comments.
proposed board responses. Right.
This is in the,
It's in the seven
the one that
B.
starts with proposal for board review.
Now,
It says FBMS rules, third publication.
it's actually under seven.
That's this copy here. And it's in red, August 19th, 2024 was the comments due. There was 2 comments.
If you go into seven B, and then at the bottom,
The basic
very bottom.
statement, yeah, that's the one I have.
So you're approving that, and then I'll make the changes from this document to the changes, and that's what will be published for another 4th publication for comment. To just this, not everything. Everything else is going to be blacked out. That's final.
Outstanding issues are
In almost every instance, we're accepting in total or in part the comments, making changes. There's a few where they're rejected. And then some of the comments would deal with the inspector issue. Take care of these changes. But I guess I'll second your motion.
I just want to make sure once that
This
Include proposed comments, the proposed response. Very common. Some do, but I'm going to leave them red. So, like other words, for an instance. Just look at that.
So we're saying that the board response to put in there for good. So for example, there's one about sub exclusions and board responses resolved the June 2024 board meeting to change the application and casino representative to those authorized to complete the application. So really,
I think there's
before that
one
was about self exclusion on Sundays, Mondays,
that
being
I just.
casino. So we're saying, I just picked one example, that we're accepting all of our responses that had previously been.
Well, no, I'm ensuring that, that we provide this proposed response to the board, from that.
Yes.
Or the red.
Yeah, the red,
The new red
the
copy.
the second publication was accepted. The third publication, only what was in red was responded to. This one here, I think that's the only one.
So board member Green, I asked the director whether the red language, that's new, comment from the third publication. I was clarifying with the director whether the responses, are responding to that red text and not prior responses. he's indicated that's the case. So these are proposed responses for you, the board, to review, consider, as responses to the comments of the third publication.
Right. Yep, this is just from the third, and these are updated with the comments here.
This is going out for another round of comment.
Mr. Chair.
Okay. Hold on. Where did you want it?
I'm gonna abstain. Honestly. I feel like I want to go back through all those comments. I'm really confused. to be honest.
Yeah, and just to remind, there is a resolution on the table presented by the unit. I don't know if that's been reviewed as well. I believe the unit, I don't want to speak for the unit. But that's been proposed to, provide guidance to licensees, regarding, how to contact the inspector. The event there isn't one. And also we're up with holds enforcement, for imposing any penalties for failure to comply with the language of the current rule as stated that requires nothing. So that might allow the board to consider any language here, that like consider prior to making any vote, address them.
Yeah, that's resolution 6.
That's what. And I do have one suggested edit if that is something the board would like to enter.
We not have a motion in a second. I think we're in discussion.
Yeah, I mean, so I guess the discussion is we hold this open. Which would delay republishing. With the inspector. Which I would like to not.
For vote. Or ask for further discussion.
So the vote on.
No, we're not there yet, not there yet.
The vote on.
It's that. What the vote is to approve the changes in the basis statement.
Yeah, you gotta do that first.
Yeah.
To incorporate. And you could also, I mean, you could also just, no, yeah, I would do that.
So, okay, well, there's a motion, so we're gonna take a vote unless there's other comments, but we don't need this. All right, anything, Joe, or did Kelly drop off?
Kelly's still there, but she had to step away for an emergency at the hospital.
I saw her putting the mask on.
Yeah. She
All right,
texted.
well, let's see if we get the votes. So start with you, Mark. Ms. Green, Mr. Hanslip. Your hand was raised, we couldn't hear you. Oh.
Unmuted.
Aye.
All right, I'm an aye as well, and Ms. Bickmore's absent, so that part's done. The second part is that when this is republished, we would incorporate the proposed changes. There's a whole bunch of sections, but do you want me to go through them all?
You don't have to, you can vote to publish the recommended changes, voted by the executive director.
Yeah.
Contained.
And in which case, there will be opportunity for public comment about these changes before we adopt this findings.
Because they're not final.
That'll be a different. So okay, I'll second it. Any discussion about that?
So this is just to publish that.
Yes.
Not to approve it, just to publish it.
Yeah, right. So we can get public comment on it. All right, so Chief March. Aye. Ms. Green. Aye. Mr. Hanslip.
Aye.
I'm an aye as well. So that will be published. I'll be part of your presentation. How long is the comment period?
The comment period is 30 days.
Okay, so we'll get them back for October.
Yeah.
Perfect. Making progress. All right, the third thing is this resolution 16, which, we'll get to your change, but the impetus for this is, I talked to the commissioner and we thought it'd be good to try to give some guidance to, the facilities. But what do we do in this interim period, before the rules are finalized? That's gonna be it. So the thought was here is that this would be a board resolution, which, correct me if I'm wrong, we can always take these back down the road. We could, in theory, put a time limit on it, but I wouldn't do that because we don't know when the rules will actually become final. That we're not gonna impose discipline to the extent it involves a notice issue because the inspector wasn't there, or they thought they weren't there, inspector was there. Whatever comes up, we can finalize.
We'll do that.
You have any questions?
I do. The expiration date, correct, Mr. Chair, this is triggered by an event date. So I would like to change the language for the expiration date, just to say that upon effective date, proposed amendments to rules contained in the chapters listed, and then, the final part of that paragraph, as voted for publication by board vote on August 27th, 2024. Just to identify.
And do we need to make reference to, although this says the board resolves to withhold its authority, like, does that affect committees dealing?
Well, the investigator, well,
Yeah.
that, it'd be futile, so if they brought a complaint up, that would be, prohibited. Or the board's not going to impose a discipline. Make note of that. I'm sure that.
Okay,
And then my motion to include the amended effective date.
okay,
And I will just send that to,
great. All right, I'll second it. Any discussion? All right. Chief March.
Aye.
Ms. Creed.
Aye.
Mr. Hensley.
Aye.
I'm an ass one. Got that wrapped up. All right. Anything else we've missed on the rules or the inspector's issues for today?
that I
Okay. You're up, God, Steve. Thank you.
With a huge thank you.
Relatively warm, I would.
I can take it on.
Likewise. So I guess I would just ask though, so guidance moving forward, we're standing by, we're gonna continue to do what we're doing. And the expectation is in the October meeting that we'll get feedback from the board about how you foresee or how you view your mission. Is that
Yeah, I
accurate?
think we're all gonna have to think about what it is.
Okay.
So we want to do, if anything.
Okay.
Perhaps by then, right, you're gonna have August, September, October, maybe some more data of here's the shipments that came in, there were no issues, or I don't know, whatever it is, I think might support continuing what we're doing. But that's not necessary. And I don't know, everyone's gonna have to think about where other board members are on it.
Okay.
As to what they want to see. But my hope is that maybe we'll get things wrapped up, but in October, but that may not be the case, in which case it's just the status quo.
And not to throw a wrench in on it, but I was just thinking, as far as the coin in and the patron play, if you talk at the casinos, they actually schedule their staffing in relation to patron play, right? They don't have a full gamut of technicians or security or whatever at 6 o'clock in the morning when there's only 10 people on the gaming floor versus 6 o'clock PM, right? So they do their staffing according to patron play, where maybe that's another way that you might want to consider taking a look at too, is maybe we need an inspector from 10 a.m. to 9 p.m. or something to that effect versus 24/7, but.
We're done, providing feedback on those particular issues. We'll talk to you again. We'll get some feedback and hopefully we'll have some additional guidance for October. We may decide to change, the data sets and the way we explain that, but we're done with that for today. So I appreciate that. Are you good with me that I know there's some agenda items presentations, I'm happy to stay, but I also don't want to leave anybody hanging if you have anything else.
Thank you.
I think we're all set.
All right. It is
Thank
good to see
you.
Thank you.
I'm gonna take things out of order. So we can we're gonna do the patron, request for that statement next. So we have two, let me pull those up. Yeah, we're skipping down to 8D and 8E on the agenda. So patron A, the reinstatement application, the statement, all of that, in the Dropbox, a pretty thorough, file, in my opinion, so. Yeah, any discussion needed here? Okay, I don't think patron A is here. Anyway, this is probably one of the most comfortable with, of all the ones we've seen. So, with that, I guess ask for a motion to approve the request for self-exclusion A to be removed from self-exclusion.
We'll make that motion with kudos to exclusion A. It's done a lot of good work. for her, so.
Yeah. Anyone want to second it? I'll do it.
I'll second.
Okay, you want to second?
Yeah.
All right, let's take a vote. Chief March,
Aye.
Ms. Green, Mr. Hanslett. Joe,
Yes,
okay, is that a yes vote?
yes,
All right, good. I'm an aye as well. So that request is approved. The next one is patron B. A little different of an explanation. But, did complete the interview with Lori at AdCare, went through the steps. So my thought is to approve it, and open to others.
So moved, approve reinstatement patron B.
I will second it. Any discussion needed? All right, Chief Martin,
Aye.
Ms. Green, Mr. Hanslett,
aye,
I'm an aye as well. So, patron B will be created. Okay, let's continue. Let's continue to, sorry, we're gonna hold it. Don't wanna step out for our rulemaking tutorial. So we'll go to 8F, which is the internal control changes, from Oxford Casino. Matthew, sorry, do you want to address?
There,
Yeah, it's better for the
let me keep you
Zoom folks.
I want your good side. I was gonna say good morning, absolutely good morning. I'm Brendan Shaw from Oxford Casino, Director of Compliance. We're here to submit our internal controls for Chapter 29, promotional credits and other flavors incentives. These were originally part of Appendix A, but removed in the last update to Appendix A. These are consistent with what was previously approved in Appendix A, but updated for current practices to address both slot and table game incentives such as free play, table games, match play, and free bets.
Any questions? I mean, I looked at it. Yeah, seemed all set to me. Any issues, Director Champion? No. Okay. So we do a motion to approve the internal control change.
Yes. So moved.
All right. Seconded by Ms. Green. Any comment? No, let's take a vote. Chief Martin?
Aye.
Ms. Green? Mr. Hanslett?
aye.
I'm an aye as well, so that may be the easiest thing to do in front of us. And then I believe there's an update from Hollywood on the Infobot system.
I believe, Jason Gill should be on the Zoom, who's our director.
Mallory, do you see Jason on there?
I'm here.
Hey,
I think I'm trying to share my camera. I just don't know which computer is sharing my camera. My
now
apologies.
you're looking at it. Yeah, look towards the straw.
Executive Director Champion and Chairman, I apologize for my confusion. I literally have GLI in my office, which is really actually pertinent to what I was about to tell you. But if what you're looking for, folks, is a high-level explanation, a very short and brief explanation of the letter that Executive Director Champion was in receipt of regarding the Imprivata product, Ms. Green, I guess I would aim my comments at the whole board, but I know that this is your particular area of expertise. So what we're trying to do, folks, is we're trying to help our gaming ops and our cashier positions in the 738 things they have to log into on a shift. And I say that with exaggeration. It's more like 5 to 7 things they have to log into. What we're trying to use is their OneSign product. So Imprivata is the company, OneSign is the software. Our corporate compliance folks thought it might be just better to be safe than sorry by notifying every jurisdiction we operate in, thus the letter to the Executive Director Champion. But what it does is this. It handles multi-factor authentication, which is what we require and you should require of us for all logins. What the gaming ops and when we pushed our multi-factor authentication to those particular groups, our cashiers and our gaming ops, what it does is it kicks them out every 15 minutes and they have to re-log into everything. We studied this product called OneSign made by Imprivata. Essentially, folks, all it does is they log into the network as their first source of sign-in, and they can either thumbprint or badge swipe as their second, thereby gaining multi-factor authentication. And then what that does is script all their logins to all their credentials, like ACSC and Every and all of the things. All it does is it is an after credential scripting service that allows these folks to multi-factor authenticate one time per shift. This is it. That's the extent of the presentation. We would be happy, board or executive director, to show it to you and let you see it if that's required prior to implementing. That's something we'd be 100% willing to do. But unless there's questions, I think brevity is called for here. So I just figured I'd give you that high level update on why you received the letter.
Yeah, thanks. Any questions?
I don't. I think it's a really good move and a big investment you guys are making, and I applaud you for it.
Is there anything you needed from us now? Just an update? All right, well, appreciate it. It seems like a good system.
Yes, sir. And again, I would invite Executive Director Champion or any of his staff, as we begin to roll it out, before we make it live, we could show it to you. So picture being worth 1,000 words, so you'd be familiar with it. But the message, Executive Director, is that nobody's credentials change. The way we credential people do not change. They don't get access to different things than is in our current security matrix. It is just a way to make their job easier.
Okay. All right, thank you.
You're welcome, sir.
All right. We've got a couple presentations from the AHEs, but what I would like to do is allow us to take any public comment now, take a little break, come back to the presentation. So if any folks have public comment or if you're on Zoom, raise your hand. Now's the time.
Just want to check for understanding the republishing rules. We'll be able to make comments on any part of that, not just the new additions.
You could,
Yes.
it's just that we already rejected. But,
Yeah,
So
you
if it's-
can,
the
if there's, yeah, I mean, if there's something specific that we need brought for attention, sure. Things have also changed since the last time you commented, so that may have led to do stuff. I don't think, yes, it's out there.
And that's, yeah, to be mindful also of internal conflicts that have been created by the subsequent publication.
We're trying to work everything out. And certainly, I think if folks feel like there's a need for a public hearing, we can think about that, but I try to get things written, get this moving forward. It's been quite a wet Monday. So, thank you, yeah. Anything else? Okay, and then I'll just remind folks, because if people want to excuse themselves, feel free. We're gonna stay, but the next meeting is in October 15th. So with that, we're gonna take a 5-minute break. We'll come back.
No.
Everybody just sit there. That's fine. He's the guy who takes the vacation day before and after. So we'll take a couple minute break and then got a presentation on board responsibilities and rulemaking process.
Great. So say German to load.
All right, we'll adjourn to 11.
11:30.
All right, so 11:40.
Unmute.
Okay. All right, we are back. We'll move to item 8B on the agenda, and it's I had asked for a presentation, about board responsibilities, the duties, given a new board member, and then just a refresher for us, been here over the years. So, Assistant Attorney General Mantis, we'll take it away.
Thank you, Chair. Again, my name is Bill Mantis. I'm Assistant Attorney General. I work with Professional Financial Regulation Division of the OAG. I'm assigned to provide legal advice to the Gambling Control Board, the Gambling Control Unit. So this is a presentation regarding the powers and duties of the Gambling Control Board, and of course, a little bit of discussion on the power and duties of the unit as well. So focus on 8 MRS, Chapter 31. Some guiding principles. The board is comprised of 5 governor-appointed members, governor-appointed chair. Board was always 3 members. We need public meeting with a quorum for action to be binding. The board is created within, but it's affiliated with the Department of Public Safety to carry out the purposes of Chapter 31. It must include 4 members, with certain expertise, corporate finance, economics, law, accounting, law enforcement, computer science, or the gambling industry. And 1 member must have experience in the harness. So just focusing on powers right now. So the board or director, and that power can be delegated to the director. So it's the board or director as delegated by the board may. This is the big power: regulate, supervise, exercise general control, etc. For the distribution of slot machines, table games, and facility casinos, and adopt rules to carry out the principle of Chapter 31. Also, some enforcement powers regarding hearings, so issuing subpoenas, or investigatory rather powers. So issuing subpoenas, telling witnesses and produce evidence. Also, there's some auditing powers that the board may impose. Also, licensing, location agreements. They have the ability to impose sanctions and penalties and cost of investigations, hearing against applicants or licensees, and other reasonable action to protect the public interest and enforce this chapter of rules without a hearing if under certain circumstances. Further.
So could I have
Yeah, sure.
just a question? The second bullet.
Yeah.
Enter into a contract with performance. What contract in that second bullet? What contracts we actually talking about? What kind of
On
contract?
the right hand side.
Subject to
Second bullet, subject to any applicable laws related to public contracts. What contracts?
So that could be, I don't think that's something we've done yet, except for maybe in the context of a hearing officer or hearing up hearings. So
We hired the time we had the hearing, we hired
Rebecca Smith.
So
So that would be a public contract.
So it's not like a contract, so like the contract with AdCare, that would fall into anything that we're responsible for.
I don't believe so.
Okay. Okay, thank you.
Sure. And this is regarding, for the enter into contract with for directors to do these. So it's.
Thank you.
The board can also negotiate consent agreements to resolve administrative violations or investigations. I've seen this before, I think, except for board member Bickmore. Ensure public safety inspectors can detain people, so basically can't provide a bullet if they can't do that. under certain circumstances. Regulate, supervise, exercise general control over the operation of data deposit state as well. So the board has power over it. Going on, before we go into duties, are there any other questions about the powers? Okay. So duties are also contained in 8.10.03 sub 2. Some of the duties are delegable. Most are. One is not. A non-delegable duty is the board providing advice and consent to the commissioner in hiring an executive director. And they can set a timetable for that kind of hiring, so they can't delegate that. However, they can delegate, and they have delegated some authority under 10.03, and that's enforcing the provisions of the chapter and any rules adopted. Pretty broad duty, and also hear and decide all licensing and registration applications. We did a few today. Review the department's reports of investigations of an applicant. We heard that today as well. Detective Armstrong cause the department to investigate any alleged violations of this chapter or rules adopted under this chapter. Moving on. So it gets a little small, the text. These slides are available for review. Again, I'm not going to read all the text. My voice gets quite tired. So referring any violations to the Attorney General, bring action to court, certain circumstances. Most issues are resolved before the board, disciplinary issues. You collect licensing, registration fees, you adopt rules to prevent undesirable conduct, fraud, deception. There's a new provision concerning move away from central-based monitoring to facility-based monitoring, ensuring that the board or the director delegable has the ability to regulate, manage, and audit the operation, data, financial data, program information, or slot machine. And that enables the department to audit the operation, financial data, program information, and casino slot machine facility licensee as required by the board. Provide the department with the ability to monitor with a real-time dashboard.
I just wanted to highlight, Steve, if you want to comment, this idea of the ability to monitor at any time on a real-time basis. No, I don't know what to think. That's sorry.
No, that's quite right. And of course, the ability to deactivate slot machines. Well, that's moved on. That's an old provision. So not via the central site monitoring system, but be able to deactivate slot machines at the facility. So that's a new provision for K. And also ensure that the slot machine or casino operators don't have access to the system that's capable of programming slot machines to change the integrity of the slot machine program. Then there's some provision regarding commercial tracks. The central monitoring, that number N, the letter N rather, is also changed as well. So I could look at those. However, it's the rule change, the statute changes regarding the facility-based monitoring is just changes the language, so that the inspectors, the GCU on site had the ability to with slot machines. They collect funds and taxes, certify monthly to the departments, a complete statement of all slot machine and table revenue, distribution, and so on. Annual reports to the governor, budgets, adopt rules regarding self-exclusion, also rules regarding the licenses to APW. I don't remember all of them, but they're all right there. So a lot of it is regarding taxes, fees that are that to the bond. So there are required rules. All the rules that are required have been made, except for the ones that are currently in application concerning facility-based monitoring. So our rules are contained in section 633 of the Code of Rules. And so section 1003 of the statute, the MRS, provides that the board needs to make rules, for example, applications for licensure, mix, ticket redemption, and so on. And so this slide provides you with a index to the corresponding chapters that show that the board has those obligations regarding requirements. It's not exhaustive, so there's additional topics, including alcohol, tobacco, weapons, advertising, games of play, the rules for the game play, slot machine testing, AEW, feeder disputes, sports facilities. Worked on now. Any questions about required for duties? The disciplinary authority, that comes from 1053 Title 8. So the board can issue a warning, suspend a license or registration for up to a year, revoke or license or registration. They can enter consent agreements, impose a fine, impose conditions of probation, impose cost investigation hearing. That's for any violations of conditions of licensure or registration. Consent agreements. The board may execute a consent agreement that resolves a complaint or investigation without further proceedings. This is oftentimes the preferred method of resolving a dispute because the one-stop shop, you don't need to have a hearing, basically a settlement of the complaint. They're not subject to review or appeal by a court. So that's not even a point that can be negotiated. Sometimes it is. In other circumstances, and it's enforceable in Superior Court by unit of the board, department, or DA's office, whatever party is necessary to enforce the consent agreement. Licensees can also surrender license or registration, so the board can accept that surrender in lieu of a formal hearing or post discipline. The board can also issue letters of guidance or concern. They're used to educate licensees regarding their obligations, express concerns over certain actions. It's not a formal proceeding. It does not adverse action, so it's not disciplinary action. But they're also not confidential. And they can be placed in public document. And also be placed in prohibition file for 10 years. And they can be accessed by the public. So they'll be. I've been guiding the board. We've issued maybe 1 or 2 letters of guidance, but they are used by the board to provide some clarity to the licensee regarding conduct that might be troublesome. However, you do need to have a violation. So you need to make a finding that there's some small violation there, but that doesn't warrant this. So it kind of rises rises to the level of more than just. The disciplinary process is fleshed out in the rules that's in chapter 27. So you really start to see how licensing actions operate. So they're submitted to the complaints, they're submitted to board writing. All of these actions start with a complaint, and they can be requested that were submitted in certain form. The department does the investigation. The designee, there isn't one. The department, headed up by Mills or Matt, anybody, deputy director, and of course, the guard. And they can ask for information from complainant, from the licensee. How to resolve these complaints, the director, after reviewing the complaint, all these investigation materials, and then consulting with the AG's office, and then issue a notice. File official notice of complaint. They also issue a notice of didn't not issuing, so they can issue a notice of complaint, start the process, issue a notice of violation, propose sanction, and enter into a consent agreement. So if you go with A first, you're asking for a response. Usually we do that. Okay, we ask for a response, then we go through an investigation. Don't go directly to B. So we may go to B if we find that there is a violation. So on. So sometimes we do a formal complaint, they just withdraw the complaint, and the response shows that back to the violation law investigations.
Is there, go back to that slide.
Yep.
Is there a Maine State Police Commander regulate the gateway?
I don't know. Is there one? That's probably old statutory language. This falls into the commissioner usually.
So, Bill, in that, these are the same complaints that we see in the complaint dashboard. So when we have ones that, let's say, 3 or 4 that are dismissed by executive director, at that point,
Right.
The executive director has to have notified
Yep.
somebody. Do they have to notify, do we get that also, what, the document also why? And the complaint might have been dismissed?
So it's the director who reviews the complaints, the investigative files. So let's say, for example, that Inspector Gardner tells Bill of some conduct that might be a violation. He reviews that information, gets a response from ICC. They dispose of it without any further response. So he
Okay, so
should
then he
provide.
doesn't have to respond. I mean, once if he's gonna dismiss it, that's sort of the end of it.
Right, so if he's provided with some information that appears to be a violation of statutes, but, upon investigation without any response, he sees that that's not the case, that would be automatic dismissal. Response being lead, shed light on whether the conduct is violation of law. Does that answer your question?
I think so.
And typically that doesn't happen until it reaches the investigative committee, which is Vicky, myself, and the AAG, right? We talk about it, so to speak.
Yeah.
And it's at that point where they think from a legal standpoint, probably should be dismissed. And then, so it's not like I make the decision before it goes to the
Yeah,
investigative.
I understood that. It
Yeah.
was really more a documentation. We have,
Yeah,
dismissed by
there's-
the board to be us, right? And then we have dismissed by the executive director, and then I guess those are the only two dismissals, right? Either board or you, and we document ours, right? If we dismiss it, and I
They are
didn't know if there was
They're all-
corresponding document.
Yeah, they're all documented. In other words, the facilities would receive a letter from me saying it's dismissed.
Okay.
Dismissed by myself or by the board, and it will be a part of that file for that. Yeah.
Thank you. That's what I wanted. Thank you.
And that one document you probably never see, or rarely see, although you may have seen it in resolving consent agreement, resolving late consent agreement, or incident reports that are generated by both the facility. But you need to make incident report, as do the facility. That's the part of the investigation.
Thank you.
So, they could, the board, the complaints can be resolved through a letter of guidance or concern as done before. There could be additional investigation, that you request from potentially the board. They'd like to see more information, presented, for example, from the consent agreement. The board would like to see information regarding the events that
I
transpired.
was just curious about what the documentation was. So I assume at any point we could request it if we saw something like a
Absolutely.
complaint that we were curious about.
Yep, it's up to the board to vote. So, you can also dismiss the. You talked about. We have to provide a notice of violation, if it's based on information directly determined that the complaint is true if the violation of sufficient gravity or further action. Remember, smaller infraction may simply warrant a letter of guidance and concern, and maybe time that might be the appropriate way to go. The notice, sets up to kind of providing what needs to be in the notice, what the alleged violation is, the statute rule, lead to have violated a proposed resolution, and inform licensee that they have the right to request a hearing. Oftentimes, complaints like this or notice of violation, that they have, that we can try to resolve this through a consent agreement. They can rights as well. And then there's a rule regarding service. The licensee has to file a written request for hearing in 30 days in order to see the hearing. The board can extend this period for good cause, if shown. So if the licensee, for example, wants to have a little bit more time to request a hearing, they can make that request. If the hearing has to be held in accordance with section 3 of the rule, and also a consent agreement it's still on the table. So even if a licensee requests a hearing, they can still resolve the consent agreement if change of shoe. Sometimes we'll see a hearing being set, and then hopefully not at the 11th hour, but sometimes the consent agreement will be reached and proposed to the board to resolve it. And then any failure to make a timely request hearing as a waiver. Hearings are, they're held in accordance with the Administrative Procedures Act. That's Title 5, Sections 951. That's SEC, and also they also have to file Right. Yeah, and then. Oh, yeah, so we can provide additional for particular procedures that those set forth. So, or want to create rules regarding hearings, the process for hearings. They can do so as long as it doesn't conflict with a map of provision. The board usually does, as do all boards, they'll appoint a contract with a hearing officer to play kind of like a judge, except that they don't make final determination regarding the resolution. They simply will take evidence, rule on motions, provide legal guidance to the board during a hearing. So it would be that hearing officer provide that guidance. And then that hearing officer will also prepare a decision and issue that decision. And then the rules simply reiterate possible sanctions available to the board or remedies that the board can use. That would be revocation, consent agreement, imposing fines, imposing the cost of hearings. Any questions about disciplinary hearing? Just I highlighted some provisions of MAPA, that's chapter 375 and title 5 that are quite important, that maybe elusive people who have never participated in a judicial tribunal want to be prohibition against like communication. So licensee can't reach out to a board member during a conversation about a matter that's before the board, pending before the board at the hearing. Just like a party in a criminal case can't reach out to the judge without the prosecution available. All parties have the opportunity to be heard through MAPA. Broad right that they have to have a hearing about delay. They have the right to present evidence, call witnesses, process witnesses, and the evidentiary standards. I think that I said here are quite relaxed in adjudicatory hearings. It's really just any type of evidence on which a reasonable person may rely. I think that they could say an important decision. Here it is. Evidence shall be admitted as kind of upon which reasonable persons are accustomed to rely on their conduct in serious affairs. There is some case law that provides contours to that language, but not. So generally, any relevant evidence simply up to the board to provide appropriate weight to that evidence. So, for example, unsworn testimony may not be provided anyway, but sworn testimony would be defined here, ready for cross-examination, greater weight to be placed on that. The board has to be aware of any conflicts of interest and also bias. Conflicts of interest for all matters is contained within chapter 31. That's 1002 sub 8. So there's a bias restriction in Title 5, Section 18, which is on the next slide. But there's also a bias provision in Administrative Procedure Act. So right, but to the left, this is for all matters. So a board member can't participate in any matter before the board if that board member has a personal bias or any other conflict of interest as the board determines, either on the board's own motion or respond to the written. So during a board member's term of service, and for 2 years after the end of that service, any person with a direct substantial interest in any gambling facility or gambling activity be not employed or be represented by the board member or the board or family. Query, I don't know how that's enforceable against an employer, simply because the board does not regulate the employers. But that is a statute that does exist. And then there is some guidance on what direct substantial. Bias is that pertains to hearings, proceedings. They have to be conducted in an impartial manner. And if there's a good faith filing by a party, a charge of bias, personal financial interest, direct or indirect, a presiding officer or agency member in the proceeding, requesting that the person disqualify themselves, that person determines whether they should disqualify themselves on their own. So they have to make that decision as part of the record. That's appealable, of course. So that's up to the individual board member. So the board as a whole expresses concern regarding a board member's ability to participate in adjudicatory proceeding. It's still up to that individual board member to make that refusal. They have the right to consult counsel regarding that. Always recommend. You can't participate in certain matters also under Title V, Section 18. You are all executive employees, meaning that you are members of the state board as defined in Chapter 37. Okay. Executive employees, they commit a civil violation, personally or substantially participate in their official capacity in a proceeding, and they know that they have a direct and substantial financial interest themselves, or their spouse, or their children, their partners.
Himself.
But that's
That's apparently only if you're male.
right. Again,
So,
right. Yeah.
So you have to vote yourself.
You do whatever.
Well, next time there's a proposed statutory change to Chapter 31, I think should a lot of the gender language, but a person or some of it's gone, first organization. So, this is a list of all those things where they have a direct substantial financial interest that would prohibit you from participating in a particular matter. So just those are the three provisions regarding bias, conflict of interest that board members should be aware of. There's also in the background something called antitrust immunity that board members should be aware of as well. State agencies may enjoy antitrust immunity, so they won't be sued for potential antitrust violations under certain circumstances. But they will not enjoy immunity if the board is comprised of a controlling number of market participants and there is adequate state supervision. The board may not enjoy antitrust immunity under that standard simply because of state supervision points. Because adequate supervision generally requires interpretation, mostly from SCOTUS scholars, because the SCOTUS precedent here is, as most of the jurisprudence have ever. But you need adequate supervision that requires a state supervisor who reviews the substance of an agency's proposed action and holds the power to overrule or modify the action, which I don't have. So I can give guidance to the board. I can tell you whether something I believe is legally copacetic or not, but it's I can't overrule your decision. So I don't have that. I may not have an adequate state supervision that will allow or to enjoy antitrust. Has been an issue, which is something. The board can delegate certain powers. We've done so before. That's been done by rule. It's been done by resolution or delegation order. And it's also been done in the past, I think, by a vote for specific tasks or actions within a limited time frame. And again, this is the board delegating to units. The delegation requires specificity. Just general legal guidance, good practice here. So we should include precise circumstances where the director or other staff may act for the board and standards for delegated decision. So the delegated power requires certain standards to be measured before making a decision. That measurement is the scope of that measurement, included the delegation. So the department has their own powers and duties. I think that's nice to discuss right before we go into the resolves. These are just inherently within the power within the department. So they can enter offices and facilities or other places without notice and to inspect, to determine compliance with the chapter. They can request to disable any slot machine. If the department has a reasonable suspicion that the slot machine or table game is being operated in violation. The department has to investigate any alleged violation of the chapter rules of the chapter under the chapter. They have to investigate qualifications of each applicant before license registration issued, investigate the circumstances surrounding the act or transaction for which board approval is required. They have to report to the board any alleged violations of the chapter. They do so with that dashboard. They have to exchange fingerprint data with, receive criminal criminal history record information from the and they have to report to the board the results of any investigation of an applicant for license registration.
Do we actually do that? Does like Inspector Armstrong, the head of Armstrong actually get criminal history commission?
Yes. It's all done through SBI. Your biggest fingerprints taken up the SBI ones, we do federal and state.
Like, is it just the person who actually signs the application, or is it like all the executive?
Yeah, it's everybody.
Okay, now, as of today, there are 16, and I haven't included all of them, but I've included all of them. They're also always in, the Dropbox. So I'm not gonna go through those right now. But there are now 16. So, public records laws, the board should be well aware of that. So this is the Declaration of Public Policy. I won't read it to you, but that's important to understand with reading Title I. Section 401, that is very important to the legislature that proceedings are open to the public. Unless there are statutory exceptions to that. There are also remote participation provisions in the statutes now. It's the epidemic. Those are reported. There is remote participation policy that the chair references with colleagues. And that's it. That's those slides. So, do I have any questions about how are the duties of the GC?
No.
Mr. Chair, would you like me to do the rulemaking?
We'll hold that.
Or would you like a poll?
Yeah, we'll hold the rulemaking. I don't have that in me. But this is good to have, because I don't know if I've seen this. I think there was a similar presentation maybe 4 years ago.
Yeah, yes. So we've
Not reviewed since then. So
started from scratch, and I will make amendments to the slides that are for the central base monitoring. Reflects the.
any board business? Jen, no longer,
And
Yeah, I was gonna see if he was gonna mention it or if he
Yeah, happy
wanted
to.
me to. Go ahead.
Jennifer is still in the AG's office, but she is taking over the board of licensure medicine. The AAG, which assigned the medicine board, is retiring. So Jennifer has been assigned to that. So we'll receive another second.
okay,
I don't think it'll be ready for the October meeting, but after that, hopefully we'll have personal by that, because that's understanding. Hire to the end of October.
I don't know. It may not be until.
yeah, okay.
So,
Okay, good for her. I doubt there is fun, but so be it. I doubt there is fun, but.
Yeah, no comment. Our grapes on her end.
All right, so our next meeting again is October 15th, 2024. And any sorts of craziness will be here, but we'll post notices and send out agendas. So with that, I'll entertain a motion to adjourn. I'll second it. I don't even know if Kelly,
No.
I saw Kelly's box.
I don't see her.
All right,
I say aye.
Joe on?
No, neither of them.
I don't know, technically we'll be there. Okay, we don't need to vote. All right, we'll just adjourn. All right,
Thank you.
thanks.
I think Chief Mark